The Honorable, the Speaker.
Almighty God, we give thanks to you, the Creator of the universe, and humbly beseech you to direct and prosper the deliberations of the members of this House here assembled for the advancement of your glory and the trust and welfare of the people of Trinidad and Tobago. Grant that peace and happiness, truth and justice may be established among us for all generations. Amen, amen, namaste.
Oath or affirmation, announcements by the Speaker.
Honorable members, I have received communication from the Honorable Ayanna Webster Roy, MP, Member for Tobago East, and Mr. Barry Padarath, MP, Member for Princestown, who have requested leave of absence from today's sitting of the House. The leave which the members seek is granted.
Bills brought from the Senate, petitions, papers.
Leader of the House.
Thank you, Madam Speaker. Madam Speaker, I have the honor to lay the ministerial response of the Ministry of Rural Development and Local Government to the 6th report of the Joint Select Committee on Land and Physical Infrastructure on an inquiry into the establishment of systems for the maintenance of drainage and roadways. Thank you very kindly, Madam Speaker.
Reports from committees, Prime Minister's questions.
Honorable members, leave having been sought and obtained on the 7th of June 2019 for the absence of the Prime Minister from the 7th to the 11th of June 2019. This item shall be considered at the next sitting of the House. Whip.
Thank you, Madam Speaker. Madam Speaker, I seek your clarification. If absence is granted, could the House state through the Leader of Government who is the acting Prime Minister, please?
All right, so I'm now on my legs. Clerk, continue.
Urgent questions.
Member for Oropuch West.
Thank you, Madam Speaker. To the Minister of Health, with regard to social media posts indicating that senior staff members at both the Port of Spain and San Fernando General Hospital stated that many Venezuelan nationals seeking medical attention are HIV positive or have malaria. Could the Minister indicate whether these claims are true?
Minister of Health.
Thank you very much, Madam Speaker. And thank you, Member, for the question. Madam Speaker, I have made no secret of the fact that malaria continues to be a source of concern. I have a reply to the Senate question number 253, which I gave to the Senate, in which I gave the breakdown of malaria cases from Venezuela. For 2019, we have 17 cases of malaria. 16 are imported and 1 local. Of the 16 imported, 13 are from Venezuela, 1 from Uganda, 1 from Guyana, and 1 from Ghana. We are treating all cases as we always do. On the issue of HIV, this country has signed on to the United Nations policy of test all, treat all, and all persons in Trinidad and Tobago, regardless of their status, whether they are a citizen, a resident, CSME, a migrant, will be tested and will be treated for HIV. Madam Speaker, in thanking the member for this question, I want to reiterate that we do not want to drive anybody underground who may have malaria or HIV. They should feel comfortable coming to our facilities to be tested and treated. We treat this as a public health issue, and I have said publicly that, that these matters will be given free of charge to anyone. There should be no discrimination, no stigmatization, and no sensationalism of this public health issue, and the government has taken a proactive stance to deal with it. Thank you very much, Madam Speaker.
Member for Bush West.
Honourable Minister, is there sufficient antiviral or antiretroviral drugs to deal with the SARS incidents?
Minister of Health.
Thank you again, member. Another excellent question, and the answer is yes. And I will explain how. Since this government took a decision about 2 years ago to switch our source of antiretrovirals to the ParlView Strategic Fund, and I said this in Parliament on several occasions, we have saved this country about $78 million, most of it due to the decreased prices of HIV antiretrovirals. And because of that, we have more than enough and can source more than enough to treat anyone, regardless of their citizenship or other status, who have tested for HIV. Let me reiterate, we have signed on to the United Nations doctrine of 1990 by 2020, test all, treat all. Thank you very much, Madam Speaker.
Supplemental member for Faisabad.
Thank you very much, Madam Speaker. Minister, as part of the registration process for the Venezuelan nationals, is consideration being given to securing medical history and possibly identifying patient, registrants who might need medical attention?
Minister of Health.
In working with the Minister of National Security from day one on this issue as to how the registration process will go, I can assure the member from Faisabad that those questions are being asked. So there will be a database on this, so we could reach out to them afterwards. So thank you for that question. It clarifies the issue. Thank you very much, Madam Speaker.
Member for Point of Pear.
Thank you, Madam Speaker. Question number 2 to the Minister of Energy and Energy Industries. Given a recent report which stated the Heritage Petroleum Company Limited has lost over $20 million due to thieves and saboteurs, can the Minister state who is the security provider, as well as the total cost for their services in the past 6 months for the said company formed under Trinidad Petroleum Holdings Limited?
Minister of Energy and Energy Industries.
Thank you very much, Madam Speaker. Madam Speaker, the company contracted by Petrotrin's successor companies to provide security services effective December 1st, 2018 with Amalgamated Security Services Limited. They are being paid approximately $2.8 million per month for providing such services.
Supplemental member for Pucci.
Thank you very much, Honourable Minister. Could you indicate whether or not these reports of larceny at the installations have been properly reported to the Trinidad and Tobago Police Service?
Minister of Energy and Energy Industries.
From my understanding, yes, they have been. Most of the pilfering and stealing is taking place not at Point of Pear, which is fairly well secured because it is a gated facility. It's taking place in the fields, which is the exploration and production field, in particular the Palo Seco Santa Flora area.
Supplemental member for Point of Pear.
Thank you, Madam Speaker. To the Minister, have any, given the areas that the theft is happening, is any consideration being given to hire back past security officers who have the experience under Petrotrin in securing those particular areas?
Minister of Energy and Energy Industries. You see.
She said,
Energy Industries.
Madam Speaker, the security contract is with Amalgamated Security Services Limited. It's a 6-month contract after which it is my understanding that the whole security services will be retendered, but this time under 3 packages. 1, Paria Garakara, which will be the point-of-care aspect of it. 2, Petrotrin non-petroleum assets, which will be the bungalows, the clubs, the houses, and what have you. And thirdly, a dedicated contract for heritage, which will be focusing entirely on field operations, which is difficult to manage because it is so widespread over the entire southwestern peninsula. You need some community support, which we are working on, and I want to urge the citizens of Trinidad and Tobago who are involved in this activity to desist. You are breaking the law.
Member for Naparima, new question.
To the Minister of Health, can the Minister confirm his recent statement that this country has adequate medical resources to deal with the growing needs of Venezuelan nationals in respect of urgent health demands?
Minister of Health.
Thank you very much again, Madam Speaker. Madam Speaker, the answer is yes, and I'll give you an example. We just spoke about malaria. To treat a Venezuelan for malaria costs $4 US. Only $4 US. Under this administration. We have also received support, both programmatic and others, from UNHCR and IDB. From those 2 international agencies, we have received not only advice, but medical supplies in drugs. We have received bed nets. We have received 2 vehicles, one which has gone to the Trinidad Public Health Lab and one gone to the expanded program on immunization. We have also received IT support. So not all the resources are coming from the taxpayer of Trinidad and Tobago. We are also getting resources from UNHCR and the IDB to deal with the urgent medical needs of migrants. Thank you very much, Madam Speaker.
Supplemental, member for Carinese.
Honourable Minister, is your proactive approach incorporating the area of testing for diphtheria and measles, which are 2 new endemic issues in Venezuela, with CDC reporting more than 6,000 cases, but measles and diphtheria?
Sorry, Minister of Health.
Thank you very much, and I thank the honourable member for his question, and the answer is yes. And that's why those 2 vehicles, one which has gone to Trinidad Public Health Lab, one to EPI, the IT support is part of the strategy of reaching the Venezuelans, especially for public health issues and diseases which can be controlled via vaccinations. We are treating them for measles and everything else, the flu vaccine, HIV, malaria, anything that is communicable, we are treating them. Thank you very much, Madam Speaker.
Member for Faisabad.
Thank you, Madam Speaker. Minister, in terms of the Venezuelan nationals accessing acute care at the emergency departments of the various hospitals, is any sort of record being formulated so that at some point in time you'll be able to give an assessment of the impact of these visits on the healthcare system?
Minister of Health.
Thank you very much, Madam Speaker. And the answer to that again is yes. Actually, I mandated the RHAs about 4 months ago at the start of this year to do just that. And we are collecting data not only on Venezuelans, because it will surprise you to know how many non-nationals outside of Venezuelans access healthcare services. So the issue of treating with Venezuelans has forced us to look at all the data, and I will have no problem at a future time making that data available to you. Thank you very much, Madam Speaker.
Member for Urupuch West.
Thank you, Madam Speaker. To the Minister of National Security, could the Minister indicate what measure, if any, has been implemented to address the increase of robberies involving Venezuelan nationals?
Minister of National Security.
Thank you very much, Madam Speaker. Madam Speaker, through you, I would like to inform the public of Trinidad and Tobago here today at 1:44 p.m. on the 10th of June 2019 at a very disturbing occurrence that is coming from those members on the opposite side and the opposition. There is no doubt in our minds whatsoever that what they are promoting is xenophobia. In fact, this morning, starting off my day with the heads of national security, I drew it to their attention that there is a specific plot by certain persons,
imputing improper motives by making negative references to persons on this side. I object.
Continue.
Thank you very much, Madam Speaker. As can be seen this afternoon by three of the four urgent questions, all based on Venezuelans. The Venezuelans are not the major cause of crime in Trinidad and Tobago, and what I can say, what we're doing to deal with it is, as I said this morning, we started off with a meeting with the heads of security, and one of the issues that we dealt with is how to deal with the continued suggestion that the Venezuelans are the source of all crime, but we're also targeting human trafficking, we're targeting those elements of organized crime, and we're also targeting those elements who may be involved in criminal activity and of a Venezuelan nationality, but they are not the only ones involved in crime, Madam Speaker.
Question, member for Urupuch East.
Thank you very much. Mr. Minister, do you agree with the statement of the Commissioner of Police that the ill-advised and ill-conceived opening of the borders and failure to protect the borders has left this country at the mercy of criminal elements coming from Venezuela? And he's not a member of the opposition.
Minister of National Security.
Thank you very much. First of all, Madam Speaker, I don't know that the Commissioner of Police made those statements and this continued tone of xenophobia by those on the other side.
Member for Naparima?
Yeah.
No? All right, member for Urupuch East, supplemental.
Thank you. Mr. Minister, do you agree with the statement made by the new ambassador from Venezuela to Trinidad and Tobago in the newspapers today, that the provision of registration cards would be a stepping stone for citizens of Venezuela to attain the status of residents in Trinidad and Tobago?
Madam Speaker, the answer is no, as we specifically said when we announced this policy, and it was announced 8 weeks ago at post-cabinet. Nothing with the registration of these persons from Venezuela gives them anything under the Immigration Act towards becoming citizens or residents of Trinidad and Tobago. We were very specific in that. This is a one-year period for humanitarian purposes, and again, the continued introduction of misinformed information by those on the other side is very disheartening. That's because you stole too much money.
Questions on notice, questions for oral answer.
Honorable members, I wish to advise, could the crosstalk be contained, in fact, wiped out? Honorable members, I wish to advise that written notice has just been received from the member for Couva South, withdrawing question 231 on the order paper. Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, we will be answering question 218, 219, 221, 231.
231 has been withdrawn.
Well, we were going to answer that, Madam Speaker. And Madam Speaker, let me just take this opportunity to say that I find it quite disingenuous that the member would only today indicate that he is not asking this question, because that is the Prime Minister indicated since last week that he would not be here and asked for permission not to be here. If I could continue, Madam. And I find it totally disingenuous because the minister, if he did not have another question, would have been brought to the Parliament. He's not a member of this House to answer a question which he did prepare and now is being told he is not being asked the question. And I find that totally unacceptable. But Madam Speaker, we are here to answer the others that are being asked.
May I ask 230? I didn't hear 230.
Madam Speaker, with regard to 230, we are asking for a 2-week deferral. Thank you very kindly.
Member for Miaro.
Question number 218 to the Minister of Agriculture, Lands and Fisheries.
Minister of Agriculture, Land and Fisheries.
Madam Speaker, on behalf of the Minister of Agriculture, Land and Fisheries, Madam Speaker, I find it passing strange that this question should come from the member for Mayaro, especially given the fact that this particular fishing facility was built by the UNC at a cost of $60 million. Similar to the library that they built and tried to open. Madam Speaker, not the library, the fire station. Madam Speaker, let me also indicate that the fishing facility is available for use by fisherfolk. However, the site is underutilized because the offshore design does not facilitate ease of landing and offloading of catches and gear. And so, Madam Speaker, it is going to be very expensive to re-engineer this facility so fisherfolk can land their fish from their boats into the facility, despite the fact that it was built for $60 million.
Supplemental member for Miaro.
Minister, for the response. Taking note of the cost of the facility, is there any opportunity to use the facility for any other purpose rather than leaving it at such minimal usage at this time?
Minister of Agriculture, Land and Fisheries.
Thank you very kindly, Madam Speaker. Madam Speaker, this was supposed to be a purpose-built facility at that cost. If we have to use it for any other purpose, we will have to have discussions with the fisherfolk and the people of Mayaro. But, Madam Speaker, it is a shame and it is sad that an attempt was made, but it cannot be used for the purpose for which it was built, because it was not purpose-built.
Member for Miaro.
Madam Speaker, question number 219, the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam Speaker. Madam Speaker, the following is a list of repair work to be undertaken for the Tableland to Rio Claro segment of the Naparima-Mayaro Road. Ongoing spot patching work in the district are being conducted in-house. Areas have been identified with line diagram for filling depressions and road strengthening for the Naparima-Mayaro Road and Rio Claro Tabaquite Road. A draft tender document for this have already been prepared and awaiting final approval, after which tenders will be invited for work. A tender document has been prepared for road strengthening and paving works on the Naparima-Mayaro Road, 3.5 kilometers to 49.3 kilometers, to be issued after depression work have been executed. Tenders were invited for replacement, patching, strengthening, and paving work on the Manzanilla-Mayaro Road, 75.5 to 87.8 kilometers. The tender are currently being evaluated. The Pure Unit executed road strengthening, rehabilitation, and spot paving works in Funrose Village around the 30.8 to 31.9 kilometer mark. Within the district, 9 landslips have been identified. They are being dealt with by the Highways Division or have been sent to the BLT or Pure for execution. Details as follows. Landslips and retaining walls. The Naparima-Mayaro Road, 46.4 to 46.50 kilometers, Agostini Village. Contracted work which was completed and supervised by Pure. Naparima-Mayaro Road in the vicinity of LP 810, House 2246, BLT. The Mayaro-Guayari Road, 11 to 11.1 kilometer, BLT. Dates Road, 4.4 kilometer, BLT. Tabaquite Rio Claro Road, 48.4 to 48.57 kilometer. Contracted work which were completed and supervised by the Highway Division. Landslips that require piling and shoring. Tabaquite Road, 46.2
46.125 to 46.175 kilometers. Tenders invited by the Highways Division. Tabaquite Road, Rio Claro, 30.5 to 31.0 kilometers. Tender documents prepared by the Highways Division and awaiting approval. I thank you, Madam.
Supplemental member for Miaro.
Mr. Minister, any indication of when some of those, the key landslips that you would have advised us, actual work may start on it, because it has been a bane of complaints that constituents are coming to me with? Any idea of when these landslips may start?
Minister of Works and Transport.
Madam Speaker, there's a process for the landslips where they have to be designed, and we do have a landslip program. Unfortunately, on that program, we have way in excess of 300 landslips. So they are being done based on the priority listing and the availability of funding. Thank you.
Member for Miaro.
Thank you, Madam Speaker. Question number 230 to the Attorney General. Sorry, pardon me, Madam Speaker. Question number 221 to the Minister of Housing and Urban Development.
Minister of Housing and Urban Development.
Thank you very much, Madam Speaker. Madam Speaker, the La Savanne is approximately 11.3 hectares and consists of both brownfield and greenfield areas. Civil works were undertaken at this site during the period February 2015 to September 2015, and again in September 2016 to January 2017. These works include water reticulation, installation of fire hydrants, drainage, and construction of a new road network and pavement structure. This site can yield a total of 111 residential lots. Approximately 51 lots are occupied with 60 vacant. There are 2 additional spaces assigned for agriculture and an open space comprising of 0.68 hectares and 2.18 hectares, respectively. With respect to Nurse Trace is approximately 6.6 hectares and consists of brownfield development where full infrastructure works were undertaken during the period February 2015 to September 2015. These include water reticulation, installation of fire hydrants, drainage, and construction of new road networks and pavement structure. This site contains 64 residential lots, of which approximately 29 are vacant. There are also 2 additional spaces for open space and commercial use, which comprise of 1.64 hectares and 1.65 hectares, respectively. For both La Savanne and Nurse Trace, the relevant statutory approvals have been received from both the Drainage and Town and Country Planning Divisions, and an application for a completion certificate from the Water and Sewage Authority has been submitted. Final approval for general plan surveys and individual lot plans from the Director of Surveys is also being sought. On receipt of all relevant approvals, a completion certificate from the Trinidad and Tobago Fire Service will be sought, as with all other approvals and certificates from the regional corporations. Madam Speaker.
Supplemental member for Miaro.
Is there any idea of when this bundle of authorizations will be completed so these lots can be given out to the appropriate applicants in those areas? Any idea of a time frame?
Minister of...
Madam Speaker, I'm unable to give a time frame. However, what I can give you is an update in terms of, with respect to Drainage Divisions, final approval has been received. With respect to Water and Sewage Authority, we're waiting issues of completion certificates. Town and Country Planning, we have received final approval. Trinidad and Tobago Fire Service, completion certificate will be given after WASA completion certificate is received. Director of Surveys, we are waiting the Director of Surveys' final approval for general plan surveys and individual lot plans. So as soon as those are given, we're good to go.
Request for leave to move the adjournment of the House on definite matters of urgent public importance. Statements by ministers.
Minister of Energy and Energy Industries.
Thank you very much, Madam Speaker. Madam Speaker, I have been authorized by Cabinet to make the following statement to this Honorable House, and I thank you for the opportunity so to do. Madam Speaker, as has been previously outlined on numerous occasions, the country's energy sector in September 2015 was not in a good place. There had been neglect of the gas contracts on both the upstream and downstream sides, and the country faced billions of dollars in claims and significant shortfalls of gas supply. In March 2018, the government held the first public account of the energy sector of Trinidad and Tobago, titled Spotlight on Energy. The objective was to provide the people of Trinidad and Tobago, the resource owners, with an account of the state of the sector and plans for the future. Madam Speaker, it is important to note that the main criticism to the Spotlight on Energy came from the opposition United National Congress and certain members of the Energy Chamber. Both the UNC and members of the Energy Chamber accused the government of being anti-investment and pursuing action that would constitute a violation of the sanctity of contracts executed with the international oil companies. The suggestion was that the revelations at the Spotlight would result in the multinational oil companies declining to further invest in Trinidad and Tobago. This suggestion was not surprising, and it was uninformed. The government immediately upon assuming office in late 2015 had been working assiduously on the energy sector, and in particular, the relationship with the international players in the sector. Under the leadership of the Prime Minister, we had been building the platform of mutual respect and an ability to sit in the same room as equals with these sophisticated multinational companies. The Spotlight was held against a backdrop of an inadequate economic return from the exploitation of our natural gas resources. The stark reality, Madam Speaker, of revenue foregone, particularly from LNG, was revealed in the gas master plan produced by UK consultants, Putin and Partners. Putin and Partners, in the gas master plan, advised that it was arguable that Trinidad and Tobago had been denied the full benefits of its revenue entitlement. They deduced that the commercial and contractual structures of the Atlantic trains had been such that little of the benefits of high global LNG prices had flowed back to the government and therefore to the citizens of Trinidad and Tobago. In the period under review, 2010 to 2014, Putin estimates that the country lost up to US $6 billion annually from transfer pricing practices during the period 2010 to 2014. In April 2018, Madam Speaker, a government team led by the Honorable Prime Minister Dr. Keith Rowley and including Minister Stuart Young and myself, met in separate discussions in London with Shell and BP to advance the matter of improving the country's position. Arising from these discussions, both Shell and BP agreed to establish empowered teams to engage government separately on LNG marketing arrangements, gas-related issues, and other important issues raised by the companies. The GORTT team entered into negotiations with BPTT in August of 2018, after a few months of preparation, which included reviewing the complex legal positions and planning our strategy. The first part of phase one of the negotiations with BPTT was completed and resulted in the approval of Atlantic Train 1 marketing arrangements, which contained a significant increase in revenue to the government based on a new formula and LNG cargoes for NGC for the first time. The extension of BPTT Southeast Coast Galeota license, which led to the sanctioning of the Cassia project. Settlement of legacy royalty gas issues and NGC domestic gas shortfall. On December 14, 2018, government and BPTT executed the agreement with respect to the first part of phase one issues. This was followed by a payment by BPTT of approximately $1 billion as settlement of the legacy issues of royalty gas and an interim payment to the NGC on its domestic gas shortfall. The negotiations with Shell began in August, but were deferred to December 2018. However, in the interim, Shell as a major stakeholder, 46% in Atlantic Train 1, was an integral part of the negotiations with BPTT on the marketing arrangements for Train 1. Arising from these negotiations, a pricing formula for Train 1 FOB price that comprised, for those of you who can comprehend this, 1/3 Brent, 1/3 UK NBP, which is the national balancing point, which is the UK market, and 1/3 the JKM, the Asian LNG market, which is the high price market, set by Japan and Korea markets, and which included the fixing of regasification and shipping costs were agreed by BPTT and Shell and accepted by the other Atlantic One shareholders, CIC and NGC. This new marketing arrangement was projected to provide government with significant incremental revenue of approximately US 118 million or 800 million TT per annum. While there has been an unforeseen delay in the life extension of Train 1 due to BP's concern about its availability of gas for the train, the shareholders are due to meet later this month to determine the way forward. The Shell-specific issues were centered around Atlantic LNG marketing arrangements for Trains 2, 3, 4, and its upstream operations. LNG consumes, Madam Speaker, in excess of 50% of the country's natural gas production, and what was identified by Putin and partners as the sector attributable to substantial value loss experienced by Trinidad and Tobago. Shell is the majority off-taker in the LNG trains, with 68% in Train 2, 73% in Train 3, and 51% in Train 4. Its LNG contract for Train 2 expires in 2022, Train 3 in 2023, and Train 4 in 2027. BP is the other significant shareholder in Trains 2, 3, and 4. Consequent on government's push at an improved revenue stream, and after months of complex and challenging negotiations, let me repeat that. Consequent on government's push for an improved revenue stream, and after months of complex and challenging negotiations, there was agreement that Shell would enhance the revenue to the government. These enhancements are estimated at approximately US $944 million over the period 2018 to 2027. US $941 billion before the expiration of Trains 2, 3, and 4. It was also agreed that in phase 2 of the negotiations, the issue of restructuring of the 4 LNG trains into a single unit would be in focus. The government will be seeking to increase the shareholding throughout Atlantic LNG. At present, government through the NGC has a 10% equity holding in Train 1 and 11.1% equity holding in Train 4, but not in Trains 2 and 3. Shell, through its investment in the redevelopment of the East Coast Marine Area, E, 5A, and 6B, have seen an increase in its gas production from an average 500 million cubic feet per day in 2017 to currently 750 million cubic feet per day. The production sharing contracts for these blocks expire over the period 2022 to 2026. To facilitate the continued production from these blocks, Shell requested an extension of the PSCs. This formed part of the phase 1 of the Shell negotiations. Government eventually agreed to the extension of the PSCs to 2030. It was also agreed to use the new Train 1 FOB price formula for future investments, which will provide improved and increased revenue to the government. Shell also requested an extension of its NCMA 1 PSC, which expires in March 2022. Shell requested the extension of the terms of the PSC to facilitate continued gas production and access to future projects such as Dragon Project and Colibri Project. Government agreed to the extension. It was also agreed to use the new Train 1 formula for further investment, which again will provide increased revenue to the government. In addition, we negotiated that subject to projected available facility capacity, government will be entitled to utilize up to 50% of the NCMA infrastructure capacity with no liability for any historic capital cost. There will be an equitable sharing of operational costs and any new capital costs. In keeping with its investment program, Shell has embarked on the development of its Colibri and Barracuda projects. For the Barracuda project 5C, first gas is projected for 2020. First gas for the Colibri project, Block 22 and NCMA 4, is projected for 2021. The government and Shell also agreed that gas supplied from these PSC and any new sanctioned PSCs for the production of LNG will be based on the new Train 1 FOB formula. It is estimated that the value of approximately US 3.3 billion will be accrued to the government from these two projects. In relation to downstream activities, Madam Speaker, the government and Shell agreed on an equitable allocation of a gas supply between the domestic market, that is the sale to the NGC, and the export market, LNG. Another major outcome of these negotiations has been the resolution of ambiguity in the interpretation of contractual arrangements between the government and Shell. A consequence of varied interpretations of these arrangements has been a suite of claims raised by the Ministry of Energy and Energy Industry and NGC and Shell. In charting the way forward, a zero settlement was agreed for all such claims except those that were not in dispute, and areas of ambiguity was resolved, and Shell, Madam Speaker, agreed to make a payment to the government of Trinidad and Tobago without any admission of liability. The outcome of these Phase 1 negotiations with Shell resulted in an agreement to pay the government approximately $397 million to the end of 2019. And the parties are moving into Phase 2 of the negotiations, which surround the restructuring of Atlantic LNG. The agreement of the upstream issues has also cleared the way for the finalization of a new Shell gas supply contract with the NGC. The finalization of the negotiations with Shell and BP has been a major achievement. The impact will be redounded to the benefit of the country with improved revenues and increased upstream activity, resulting in a stable and improved gas supply. The heads of agreement with Shell embodying the above issues was signed on Wednesday, the 29th of May, 2019, in The Hague, Netherlands, at the head office of Royal Dutch Shell, PLC, and will be followed by definitive agreements, which will be finalized over the next 2 months. For the records, the Minister of Energy signed the agreement. Madam Speaker, these have been landmark agreements that will benefit the people of Trinidad and Tobago. I wish to acknowledge the strategic direction of the Honorable Keith Rowley, Prime Minister of Trinidad and Tobago, whose guidance enabled a successful and positive outcome to the negotiations. I wish also to thank members of the Government Empowered team, which I chaired, but which also included the Honorable Stuart Young, Minister in the Office of the Prime Minister, Minister of National Security, and Minister of Communication. Advisors, U.S. Attorneys White and Case, and our UK consultants, Putin and Pardon. Madam President, Madam Speaker, I will also go as far as saying, never before in the history of this country has a Trinidadian team and energy negotiation been so well prepared. Madam Speaker, it will be amiss of me if I did not express sincere thanks also to the international oil companies, in particular Shell and BP, for the professional manner in which the negotiations were conducted and their appreciation of our concern. This led to agreements which are to our mutual benefit. As part of the continuing development of our relationships with the IOCs, the opportunity was taken to meet the decision makers at the energy capitals of the world. Hence our visit to The Hague, where we met with the hierarchy of Shell, in London with the hierarchy of BP, in Houston with the hierarchy of BHP and EOG. Madam Speaker, contrary to negative assertions by our detractors, all the IOCs, that is Shell, BP, BHP and EOG, have assured of continued investment in the upstream in Trinidad and Tobago. It is this commitment that has resulted in an increased gas production from 3.3 BCF per day in 2016 to 3.8 BCF currently. In closing, Madam Speaker, this government has always stated that it welcomes investment, but that the resource owner, which is the people of Trinidad and Tobago, must enjoy a fair economic rent. We make no apologies for that. Through our efforts, this is now clearly understood by the IOCs and has translated into the economic gains that we have collectively achieved. These benefits will accrue to the people of Trinidad and Tobago. This is in keeping, Madam Speaker, with the commitment of this administration to work for and on behalf of the people of Trinidad and Tobago. Madam Speaker, I thank you.
Member for point of view.
Madam Speaker, 24-4. To the Minister. Minister, in the early part of your speech, you talked about transfer pricing and loss of revenue between 2010 to 2014 under the PP government. Could you state how many billions of dollars have been lost under your government between 2015 to present under transfer pricing, please?
Minister of Energy and Energy Industries.
We haven't lost significant revenue. But Madam Speaker, this is the solution. It took 2 to 3 years of serious negotiations because, as the multinationals had said, they broke no law, they breached no contract. It was engaging them around the table as equals and say we have to sit down and talk. And it is the very UNC that accused us of breaking the sanctity of contracts. So if you were in power, it would have remained the status quo. Today we have changed the status quo.
Personal explanations, introduction of bills, motions relating to the business or sittings of the House and moved by a minister, public business, government business, bills second reading.
The Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to move the following motion standing in my name. Be it resolved that the Senate amendments to the Administration of Justice Indictable Proceedings Amendment Number 2 Bill 2019 listed in the appendix be now considered.
Clerk. Now, Attorney General, these are not motions.
Sorry, I'm reading from the procedure given to the clerk.
Honorable members, the question is that the Senate amendments to the Administration of Justice, Indictable Proceedings, Amendment Number 2, Bill 2019, listed in the appendix, be now considered. All in favor say aye. Aye. Any against? The ayes have it.
Clause 5. A, in subsection 3D, delete the words "the evidence filed before the master discloses" and substitute the words "there is." B, in subsection 3E, delete the words "child witness" or "an adult witness who has been assessed as one subject to threats, intimidation, or elimination," and substitute the words "child accused" or "child witness" or "an adult witness who has been subject to domestic violence, threats, intimidation, or elimination."
Attorney General.
Thank you, Madam Speaker. Madam Speaker, the Senate in its deliberations held on the 6th of this month considered that improvement to Clause 5, which proposes an amendment to Section 6 of the Parent Act, should be made, should be had, specifically with respect to subclause 3D, that the evidence as described coming before the court ought to be considered in a wider fashion than the bill proposed. Madam Speaker, this clause 5 in amending Section 6 of the Act is treating with the circumstances where the DPP may prefer an indictment in very specific circumstances. They are very similar to the substantive provisions contained in Section 27.3 of Chapter 1201, that is Act Number 12 of 1917, the current law. In Section 27.3 and in Section 6 of Act Number 20 of 2011, we have the position of the DPP being able to prefer an indictment in what we call usual circumstances, where there's a coroner's inquest, where a co-accused is arrested at any time before arraignment, where the accused is charged with an offense involving serious or complex fraud, and where a magistrate was unable to complete a preliminary inquiry in certain circumstances. It is in this situation, what I will call the Marcia Ayres Caesar clause, now that that litigation is over, that subclause D finds life. The amendments which came from the government included the circumstance of having an indictment preferred by the DPP in the following circumstances: where a magistrate or a master could not complete a sufficiency hearing or a preliminary inquiry. Firstly, where there was a physical or mental infirmity. Secondly, a resignation. Thirdly, retirement. Fourthly, death. And fifthly, where there was an inability for any other compelling reason. It is that fifth aspect which is novel. Those circumstances were put within another context, and that is the evidence in those proceedings, that is the sufficiency hearing or in the preliminary inquiry, which for want of a better expression had to be abandoned. The evidence as described, which ought to follow into the indictment, was described in the bill as evidence filed before the master discloses, in the opinion of the DPP, sufficient evidence. Those words, if we had used them alone, would mean that we were only catching a sufficiency hearing, because it is only a master that conducts a sufficiency hearing. In the circumstances, we propose the deletion of the words "the evidence filed before the master discloses" and simply refer instead to "and there is, in the opinion of the DPP, sufficient evidence." That would allow us to catch the circumstance of evidence which was led both in the preliminary inquiry before the magistrate and in the sufficiency hearing before the master. In those circumstances, therefore, we enlarge the evidential package moving with the indictment, and we don't confine it only to the circumstance of a sufficiency hearing. That is the rationale for the proposed amendment to subclause 3D. When we turn, Madam Speaker, to subclause 3E, as in echo, we are treating now with the circumstance where, in the case of an offense of a violent or sexual nature, and where there's a child witness or an adult witness who has been assessed as one subject to threats, intimidation, or elimination. Now, Madam Speaker, this is the circumstance where the DPP will avoid having a sufficiency hearing before a master or avoid having a preliminary inquiry before a magistrate. That is one that was under the old law, if I may call it that. And instead prefer an indictment directly, skip past those preliminary matters, find constitutional treatment under the umbrella and protection of the Privy Council dicta in Hilroy Humphreys. And in these circumstances, Senator Choate, in fact, made a very poignant and commendable recommendation that we should broaden the opportunity beyond just child witnesses and, in fact, include a child accused. Because a child accused being before a court without proven innocence or guilt yet, i.e. on a charge, is as vulnerable as a child witness. And therefore, it is opposite to the best interests of society, democracy, and rule of law within the Constitution to consider an improvement of the category by adding in the concept of a child accused. These, Madam Speaker, are the recommendations emanating from the Senate and the reasons for the proposed amendments to Clause 5 of the bill. And, Madam Speaker, I take it that we're taking each of the clauses clause by clause? Yes, and so I beg to move those amendments with respect to Clause 5.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 5 of the Administrative Justice Indictable Proceedings Amendment Number 2 Bill 2019. Member for Point up here.
Thank you, Madam Speaker. I don't propose to be long as the Attorney General. I think I might be shorter than what the Attorney General said. But just to agree with the Attorney General, the amendments came from the Senate after a couple of days of sit-ins, and they fleshed it out up in the upper house, Madam Speaker, and they brought 3 amendments, and they brought it back to our house to approve. And out of the 3 amendments, I want to also compliment our opposition senator, Opposition Saddam Hussein, who worked with the Attorney General, especially in agreeing. I want to thank the Attorney General in agreeing with Clause 11 to delete that subsection. So, Attorney General, I thank you for that.
Point up here, all that is before the House is the amendment to Clause 5. Okay?
Sorry. Oh, we didn't do it all together? All right, Madam Speaker, if we're doing clause by clause, I don't have anything at this point in time. So thank you.
Attorney General.
Madam Speaker, first of all, I'm surprised that not a single lawyer opposite could stand. I didn't know Pointe-a-Pierre was schooled in law. So I accept the fact that he would have been as short as he is, because he's certainly quite less qualified than certain others. However, Madam Speaker, it goes a little bit further. These amendments to Clause 5 certainly did not come from Senator Hussein. So I don't know what my learned colleague was listening to, what he was reading, or where he has come from. These amendments now stand before us as simply a prudential requirement coming from the Senate. So my learned friend is lost. He is in the wilderness in terms of the origin of these matters, and I beg to move.
Honourable members, the question is that this House agree with the Senate in the amendments to Clause 5 of the Administration of Justice Indictable Proceedings Amendment Number 2 Bill 2019. All in favor say aye. Aye. Any against? The ayes have it. May I inquire if there's agreement to do clauses, the amendments to clauses 10 and 11 together? Yes. So, Attorney General.
Madam Speaker, I beg to move that this House agree with the Senate amendments to clauses 10 and 11 of the Administration of Justice Indictable Proceedings Amendment Number 2 Bill 2019.
Clause 10, delete subsection 6 and substitute the following new subsection. 6, depositions taken in, witness statements filed in, exhibits admitted in, and any relevant portion of the record of proceedings instituted prior to the coming into force of this act may be admissible as evidence at the trial of an accused. 11, in subsection 32A, delete subsection 5B.
Attorney General.
Thank you, Madam Speaker. Madam Speaker, in taking these two clauses together, the amendments to Clause 10 and to Clause 11, in Clause 10, it is in fact here that Senator Hussain made an input, and I thank him for that. It joined the input. Don't get too anxious, Nasiparia. Let's take it clause by clause. So, in Clause 10, Madam Speaker, would you control Naparima?
Attorney General, please continue.
My learned friend thinks that calling Siparia is obnoxious. Has no concept of the rules of this House.
What's going on here?
Madam Speaker, I don't know what possesses Naparima. Anxiety or perhaps condition. Madam Speaker, we're dealing with Clause 10. Clause 10, despite my friend's discomfort opposite, involves an amendment to subclause 6 of Section 29 of the Act. Section 29, as originally posed, which treats with depositions taken, exhibits admitted in proceedings instituted prior to the coming into force of the Act, shall be admissible as evidence at the trial of an accused. Senator Choate and Senator Vera considered that we should be a bit more expansive in language. It was at this point that Senator Hussain commendably agreed with that position, and the government in any event had proposed some considerations in the context of debate. And we instead proposed, Madam Speaker, even though the language in subclause 6, that is in Clause 10, is clear and replicated Act number 20 of 2011, i.e., the original law passed by the UNC and supported by the PNM in 2011 before the proclamation of Section 34, that original law, that Section 6, subsection 6, is word for word the same. So it isn't that there was any newfound novelty on the UNC bench for this position. Instead, in the rules of legislative contemplation, Senator Vera pointed to quite an interesting point, saying that we ought to consider larger parts of the record more than just the reference to depositions taken, exhibits admitted in proceedings. Taking a view of erring on the side of expansive caution, the Senate agreed instead that we would amplify the language in subsection 6, so that we now would introduce into continuing proceedings depositions taken in, witness statements filed in, exhibits admitted in, and any relevant portions of the record of proceedings instituted prior to the coming into force of the Act may be admissible as evidence at the trial of an accused. Now, it's important to note that the relevant part of this is really relevant portions of the record of proceedings, insofar as there may have been an endorsement on a document which is other than a deposition or a witness statement. We went with that parts of the record of proceedings. And secondly, even though the language specifically in 2012, 2011 referred to evidence being automatically introduced by virtue of the word shall, we opted to use the word may. This is in deference to the admissibility being a judicial function, and therefore just out of a little bit of extra caution to ensure that we don't have to rely upon the rules of statutory interpretation where shall is read as may in certain circumstances, and so that we could not find ourselves in any argument that we were usurping judicial discretion in the admissibility of evidence. These are the considered reasons for the amendments to Clause 10. Madam Speaker, if we turn to Clause 11, and Clause 11 is the clause that introduces a new 32A. 32A is the companion procedural clause which runs alongside Clause 4 of the legislation. The Parent Act is amended in Clause 4 of the primary legislation so that we can treat with a process of bringing someone before the court in circumstances where they were not brought by a sufficiency hearing, and therefore they were just simply brought before the court. The application function, which is what Section 4 is, says that subject to subsection 2, the Act shall apply to proceedings which are instituted on or after the coming into force of the Act. We amended it as a House by modifying subsection 2, and we're saying subject to subsection 3, where proceedings were introduced prior to the coming into force of the Act, the prosecutor or the accused may elect to have the case determined in accordance with the Act, and Section 32A shall apply accordingly. 32A is the process where we now get into bringing forward how you come before the court. Now, I must underscore that the UNC's on-the-record position, the opposition's on-the-record position for preliminary inquiries to be abolished, and therefore how we treat with the arrears, their on-the-record position is that they would not support the fact of either party electing. They insisted in the Senate, as a matter of fact, that the consent must be had between the prosecutor and the defense. That would make a mockery of the 32,000 cases that are in arrears. That was said in the House by the honorable members when we debated the bill the first time. And in the Senate, the insistent, every single person on the bench position of the UNC was that the defense and the prosecution had to consent. It was pointed out to the members of the opposition that that would effectively mean that defense attorneys who wish to prolong hearings for 10 and 20 years further would ride roughshod over a prosecution which was ready. And we would have none of that. And dare I say, it appeared that the independent bench would have none of that. For the issue of management of shame, it was when we got to the voices being collected that the opposition stayed fairly quiet. But I want to go on record to say, true to form, perhaps in the spirit of the early unseemly proclamation of Section 34 of the legislation, Clause 34, the UNC's position was defense must agree with prosecution to convert the matter out of a preliminary inquiry. And I find that an incredibly offensive position from logic and cost perspectives. Madam Speaker, it is in Clause 32A, as it is introduced here, that the process of management falls for consideration. And 32A provides in the transitional proceedings where the prosecutor or accused elect under 4.2 and subject to 4.3 to have a case determined in accordance with the Act, the magistrate shall order that the accused be brought as soon as practicable before a master. That situation is in causing, after the election, the movement of the file out of the magistracy and to the High Court. The subclause that is being amended here, when we look at 32(3)(a) and B, where a magistrate makes an order under 1 or 2, the magistrate shall issue a notice to the registrar specifying the offense or offenses with which the accused has been charged, and the magistrate shall cause a copy of the notice to be filed in the High Court and served on the accused, and a copy of the record of the proceedings, etc. When we get down to subclause 5, which is what the Senate is now proposing be amended, we said where an order is made above, that the accused shall appear before a master on the next available session day as determined by the registrar. Subclause B provided for a very useful mechanism, and that is where either party could consent together with the master to vary the date on which you appear. In other words then, exactly like the civil proceedings rules, which allow for a variation of a court timetable or orders of the court by consent, where you file a consent application, both parties sign the consent application, you serve that consent application, it would have avoided the need for people attending at trials to only have their dates removed. This novelty, this commendable process by subsection 5B, the Honorable Senator Choate felt that it was prudent to take this in steps. Honorable Senator Choate asked us to consider simply allowing the Route A option to pass, which is that you would appear on the next available session day as determined by the registrar, and avoid the aspect of attending by consent. The government was prepared to agree with that because under the criminal proceedings rules, we have the option to do some case management. My own preference in terms of advice is that I would have felt a bit more comfort in the parent law speaking to this provision, but I thought it an important step towards operationalization that we took it in careful measure. For those reasons, we took Senator Choate's recommendation and are now recommending that we delete subclause 5B and leave only the availability to appear on the next available session day as determined by the registrar. These in the round are the amendments proposed from the Senate with respect to clauses 10 and 11, and I beg to move.
Honorable members, the question is that this House agree with the Senate in the amendments to clauses 10 and 11 of the Administration of Justice Indictable Proceedings Amendment Number 2 Bill 2019. Whip.
Thank you, Madam Speaker. Madam Speaker, I'm so heartened to hear the Attorney General. And these are just two simple amendments, and I've listened to the Attorney General for the last 10 minutes or so talked about Clause 11. And Clause 11 just states, in subsection 32A, delete subsection 5B. That's what it is about. It's a simple thing. So, Madam Speaker, I wouldn't belabor the point, and I just want to put on the records, the deletion of that amendment was due to the input by our opposition Senator, Saddam Hussein. And it is there on the record, Madam Speaker. And Madam Speaker, as I close, it is often said that the road to hell is paved with good intentions. And Madam Speaker, it is not enough by the Attorney General to simply mean to do well. I want to tell him his action must do well, Madam Speaker. So I thank you.
Madam Speaker, simplicity is often in the complexity of the mind or lack thereof of the person appreciating the argument. I cannot assist my learned colleague who has no training in the law as to what is simple or not simple. For the government, this is a serious matter. For Naparima, it might be a joke. Similar to surgeons in the United Nations. For this bill, this is a serious matter. And if the best that the opposition could do is to try and tell us who came up with a suggestion and how simple a deletion of a clause is, yes, sometimes simplicity resounds that way. Best found when you decide that you're going to simply proclaim Section 34. Simple measure, massive consequences. So, Madam Speaker, in dealing...
48-1.
Madam Speaker, simple consequences have profound circumstances. And in answering my learned colleague's position that this is a simple matter, Madam Speaker, it is no simple matter. Let us deal with something further. Again, my learned colleague would be reminded that the Parliament has invested a whole lot of money in the transcription of words, a whole lot of technology and money in the ParlView mechanisms. It was Senator Sheikh who actually made contribution on this particular aspect after Senator Choate spoke. And again, my learned colleagues will just not pay attention. There was a young attorney appearing on behalf of the honorable members.
Standing order 48-6. I pay attention.
Continue, Attorney General.
Thank you. I don't know what you pay attention to. Madam Speaker, the lack of generosity of spirit is for other people to decide. In terms of dealing with the proclamation of the abolition of preliminary inquiries, this government will march on to make sure that every matter of complex fraud and corruption and abuse of the tax-paying dollars finds a chance to find life within these amendments before us now, where the DPP can proffer the route by which you come to bring existing proceedings before the court within the context of 32(5)(b) being abolished. My learned friends don't understand that. It was Pointe-a-Paix on a previous occasion in refusing to support legislation, said they will not support legislation because they now see the pieces of the puzzle come together. And this simple amendment to 32(a)(5)(b) is to allow for persons who are under the existing preliminary inquiry route to be brought with alacrity before a court. And that might panic my learned friends opposite, to know that persons who are charged will find themselves before a court to answer for their criminality. That might panic my learned friends opposite. It does not panic the government. So, simple Simon, simple statement, complex issues. These issues are of important measure to us. It may be that NAPRIMA can't contemplate that, but we understand NAPRIMA's limitations, Madam Speaker. And I ask, Madam Speaker, that we remind that sometimes education takes you out of certain lurches of comprehension and management. Sometimes people might believe that money takes you out of that lurch. But Madam Speaker, one's management of intelligence against one's prosperity has nothing to do with common sense or morality. And I will understand why some people have great difficulty in understanding those measures. I beg to move.
Honorable members, the question is that this House agree with the Senate in the amendments to clauses 10 and 11 of the Administration of Justice, Indictable Proceedings Amendment Number 2 Bill 2019. All in favor say aye. Aye. Any against? The ayes have it.
Bill's second reading.
Attorney General.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Financial Institutions Act, Chapter 7909, the Securities Act, Chapter 8302, and the Insurance Act Number 4 of 2018 be now read a second time. Madam Speaker, we come before this Honorable House to treat with a continuation of measure of improving our technical compliance as well as our efficiency matrices as we are gauged by the Financial Action Task Force. It's a matter of public record that in January 2015, Trinidad and Tobago underwent its fourth round mutual evaluation. We were selected by the Kamla Prasad Bisesa, member for Siparia government, to be the first country in the Caribbean Financial Action Task Force regime and one of the first countries in the world to undergo fourth round mutual evaluation. This decision was taken even though this country was not ready for a fourth round mutual evaluation. And that is evidenced by the fact that we had not in fact completed our third round mutual evaluation. But prudence, UNC style, decided that we would roll up the third round mutual evaluation together with the fourth round mutual evaluation and put Trinidad and Tobago into the matrix of being assessed first in the world. Needless to say, Madam Speaker, what happened was nothing short of a catastrophe. Trinidad and Tobago failed in significant measure its fourth round mutual evaluation. We were put into two levels of compliance. The first level of compliance is called enhanced follow-up in the Caribbean Financial Action Task Force regime. And the second level of compliance was being placed on a public listing under the Financial Action Task Force, ICRG, or that is your International Cooperation Review Group, where Trinidad and Tobago was placed on a list effectively by the Financial Action Task Force, telling the whole world that this country has strategic deficiencies in its anti-money laundering and anti-terrorist financing laws, Madam Speaker. In that determination by the FATF and the CFATF, Trinidad and Tobago had to commit itself, after the publication of its fourth round mutual evaluation in June 2016, we had to commit ourselves to a 3-year action plan. That 3-year action plan saw Trinidad and Tobago under an obligation to improve its ranking with respect to compliance against the 40 recommendations, and also to improve its ranking on the immediate outcomes, the 11 of them, against those technical compliance positions. Let me explain that. The fourth round says, let me see if you have a law. If you have a law to treat with certain things, you will be deemed to be technically compliant. But the immediate outcomes say, let me see what the outcome of your technical law is. In other words then, do you have something to show for it? What we have here, Madam Speaker, is the determination by the Financial Action Task Force that Trinidad and Tobago has a strategic deficiency in its compliance with recommendation 7 and immediate outcome 11. This, Madam Speaker, is something which is of great importance to us in the government. Now, Madam Speaker, I'm able to say in very guarded senses that Trinidad and Tobago just had last week its review by the Caribbean Financial Action Task Force. We can't speak publicly or prematurely as to what that review came in, but I am going to say now that Trinidad and Tobago can expect to be very pleased at the work that this government has done, and when those results are capable of being published after the technical compliance and quality and consistency issues happen, the country will be, by way of publication, in a much better position. Madam Speaker, my friends opposite will not even bother to control the murmuring. Could you ask them, please?
Okay, so I just, Whip, I'm sure you didn't mean to suck your teeth, okay? But I'll just ask us all to be mindful of how low our ceilings are and to control our volumes. Member for San Fernando West.
Thank you, Madam Speaker. So, Madam Speaker, the Financial Action Task Force has its meeting on Sunday, 16th of June. We are now at the 10th. This Sunday coming, Trinidad and Tobago is required to face the music. We will be called upon, I as the representative for the government will be required to attend before the ICRG group, the International Cooperation Review Group, and we will have to be assessed by the Financial Action Task Force to see where we are on our action plan, where we are on the implementation of technical compliance, how we have performed on our immediate outcomes, and that begins this Sunday in Orlando, in the United States of America. The recommendations coming from the International Cooperation Review Group will go to the plenary session, which will be held Wednesday, Thursday, Friday, and Trinidad and Tobago will be at the table with all 190 countries of the world watching as to whether we have achieved what we can. And Madam Speaker, this is of serious import, because we will be the first country to come to the end of the railroad. The tracks end. And as those tracks end, having compliance from the technical compliance and the immediate outcomes, what is your effectiveness, falls into sharp focus. Madam Speaker, permit me to tell you this. When we appeared before the Joint Review Group in April of this year, Trinidad and Tobago I sat together with our team for Trinidad and Tobago across a room full of assessors. That room full of assessors coming from the World Bank, Mexico, Spain, the United States of America, England, France, a number of jurisdictions, the FATF, they looked at us. And Madam Speaker, do you know what they did? They read out our newspaper articles to us. They read out the comments of the opposition to us. And Madam Speaker, I had the obligation with a straight face to try and explain to the international assessors, don't take on the UNC too seriously. And Madam Speaker, I'm being very serious now. We were told, but this is your opposition, condemning laws against civil asset forfeiture, condemning laws on explain your wealth, condemning the law on non-profit organizations. This is your opposition, and we had to explain to the world that we have a unique constitution, that our Republican constitution, cast with its 3/5 majorities, 2/3 and 3/4 majorities, pursuant to Section 54 of the Constitution, as they relate to Sections 4 and 5 rights, that we have an obligation to gain acceptance. But Madam Speaker, there was a large elephant in the room, and that elephant was trying to explain in diplomatic speak why it is our opponents opposite cannot agree to things which the whole rest of the world see as axiomatic and proper for agreement. So, Madam Speaker, one of the observations hitting us by the FATF, by the joint group, is that we have to make an improvement to recommendation 7 and to immediate outcome 11, in particular recommendation 7.3. Recommendation 7.3, coming from the methodology of the FATF, effectively says countries should adopt measures for monitoring and ensuring compliance by financial institutions and DNFBs, BPs, that's designated non-financial business and professional entities, with the relevant laws or enforceable means governing the obligations under Recommendation 7. Failure to comply with such laws or enforceable means should be subject to civil, administrative, or criminal sanctions. Let me explain that technical speak. This Recommendation 7 anchors squarely in what we call proliferation financing. Proliferation financing is a term of art which we in this bill propose an introduction. We say in this bill, Madam Speaker, across the several clauses, and if you treat, Madam Speaker, with Clause 2, with Clause 3, and Clause 4, you will see that in causing amendments to the Financial Institutions Act, the Securities Act, the Insurance Act, we introduce into each one of those laws a definition for proliferation financing. Proliferation financing refers to any means of providing funds or financial services used in whole or in part for the manufacture, acquisition, possession, development, export, etc. of nuclear, chemical, biological weapons, their means of delivery, etc. In other words, then, we are treating squarely with the movement of funds, and we would be foolish to think that funds do not move through our offshore accounts as they exist in our jurisdiction, or through our onshore accounts, because they may be innocuous movements. And the movement of funds as it relates to proliferation financing has to be managed across the regulated sectors. Now, Madam Speaker, the Financial Intelligence Act, that is an act of Parliament in 2009, that Financial Intelligence Act vests in the FIU a very wide-ranging function. That wide-ranging function includes the imposition of guidelines, monitoring, effectiveness, powers of entry, supervision, etc. But, Madam Speaker, we don't have, for the other articulating laws, the securities laws or the insurance laws, the same type of structures that we have for the FIU legislation. It is imperative for us to anchor down the performance of financial institutions and non-designated financial institutions, effectively everybody else. The 5th schedule of the Proceeds of Crime Act sets out what listed businesses are, what entities that have to comply with the regulations look like. But, Madam Speaker, we did not have in required detail the mechanisms to treat with proliferation financing as we manage it. Now, Madam Speaker, our jurisdiction elected to manage proliferation financing by the publication of orders under the Economic Sanctions Act. We did a debate, we brought these orders forward, we affirmed those orders in this House. We heard a song and a dance from Naparima threatening that the publication of the Iran orders was something which contravened the United Nations. The member threatened to come back and move a motion of privilege on Iran orders. We are now 6 going on 7 months later, and the honorable member can't yet produce a scrap of paper to justify his charges, and he will be properly answered when I wrap up this debate. Again, hopefully not as embarrassingly as the first time when you raised it. But Madam Speaker, our Economic Sanctions Act and our orders manage our proliferation financing. And I'd like to say, Madam Speaker, what time is my full time in end?
3:32:33.
Thank you, Madam Speaker. Madam Speaker, our implementation of our proliferation financing regime is intended to treat with the operationalization of our UNSCR obligations, our United Nations Security Council resolutions, implementation as they relate to the North Korea situation and the Iran situation. Now, the North Korea situation is a very large context. Effectively, there's a heavy blacklisting of North Korea. Iran has been the subject of a lifting of the weight of sanctions, and the joint groups that dealt with the lifting of Iran sanctions really only left a few of those sanctions into effect. But the United Nations listings have confirmed the prevalence and existence of sanctions against Iran. In Trinidad and Tobago, I'm pleased to report that our High Court has listed 80 individuals and 75 entities against UNSCR 1718, and we have done 23 individuals and 61 entities against United Nations Security Resolution 2231. Those are the sanctions listings. So let me repeat that. Trinidad and Tobago's High Court has approved the issuance of sanctions under the North Korea sanctions regime and under the Iran sanctions regime. And our High Court could only have done that on the back of the UN confirming the validity and existence and non-removal of those sanctions, both for North Korea and for Iran. Madam Speaker, what is required in terms of our operationalization of this law is a position of improvement of, firstly, the Financial Institutions Act, secondly, the Securities Act, and thirdly, the new Insurance Act, Act number 4 of 2018. When we look to the bill, the first clause, which treats with the first laws to be amended, we propose in clause 2 to amend the Financial Institutions Act. The first thing we do is we amend section 2 of the Financial Institutions Act. We insert a definition of proliferation financing. We then, Madam Speaker, cause an amendment to section 10C of the FIU legislation, and then 32(2)(o), O as in Oscar. Clause 2, in amending the definition, we take one definition as it is harmonized under the economic sanctions regime. We introduce the definition of proliferation financing. Secondly, we deal with clause 10, section 10. In section 10, we're treating with the issuance of guidelines. We say that the central bank may issue guidelines on any matter it considers necessary to c. aid compliance with the Proceeds of Crime Act and the Anti-Terrorism Act. We're adding in the Economic Sanctions Act or orders made thereunder as they relate to proliferation financing. And Madam Speaker, we actually propose a few amendments to this legislation. We have been asked by the Securities Exchange Commission and the Central Bank to consider improving the wording by adding in Act and any regulations made thereunder, so that we'll be treating with the regulations also under the anti-terrorism regime, not just the Proceeds of Crime Act or the Economic Sanctions Act, but also the Anti-Terrorism Act by incorporating its regulation regime. Madam Speaker, of course, in this clause 2, we also propose who is to be debarred from management. And under Part 4 of the FIU, of the Financial Institutions Act, forgive me, I keep saying FIU, it is the Financial Institutions Act, Chapter 7909. Under the Financial Institutions Act, Chapter 7909, we deal with Clause 2, definition of proliferation financing. We deal with Section 10, which is to put how guidelines can be issued by the central bank for all of the entities that it regulates. And under Part 4 of the FIA, the Financial Institutions Act, we're saying who shall be disbarred from management. And we're adding in that category of persons who have been the subject of orders made under the Economic Sanctions Act or the Anti-Terrorism Act and its regulations. So we are specifically making sure under the Financial Institutions Act that we debar this category of persons. Madam Speaker, Clause 3 proposes amendments to the Securities Act, Chapter 8302. Sure.
You just mentioned the Financial Institution Act. Where does credit unions fall? I know it falls under the Trinidad Cooperative, and I didn't see it in you.
Credit unions are not a financial institution. That's been the subject of a small 30 years of debate in this country. They regulate approximately 7% of our sector. This government is actually managing that sector by way of an active project right now. We have explained that situation to the Financial Action Task Force. They are comfortable with that at present because we have calculated the risk behind that sector. There are guidelines and regulations, albeit not in the best way possible for modern standards, but we have engaged the credit union sector already. We're in discussions with them on that. Madam Speaker, Clause 3 of the bill treats with the Securities Act. The Securities Act, Chapter 8302, we propose amendments to Section 4.1, Section 6.1, Section 57.1J, Section 58.26, Section 87.1A, Roman 3, Section 89.1, Section 91C, Section 146.1C. And Madam Speaker, effectively the amendment to Section 4 of the Securities Act is to add in the definition of proliferation financing. The amendment to Section 6 is an important one because it is here in Section 6 where we treat with the powers of and functions of, the SEC, the Commission's functions. It was important for us to add in language to subclause I, as in indigo, and instead of only having compliance with the Proceeds of Crime Act, we are adding in the Anti-Terrorism Act, the Economic Sanctions Act, or any orders or regulations that those may traverse as amendments to be circulated will also amplify. Madam Speaker, we then look at Section 57 of this SEC legislation. We're causing an amendment to 57.1J, and again, we are treating with the issue of warnings. We're allowing the Commission to issue warnings to a registrant, and we're saying that the registrant should be also warned that they may be prosecuted for breaches of, again, Proceeds of Crime Act, Economic Sanctions Act, Anti-Terrorism Act, as they traverse that spectrum. When we deal with the amendments to Section 58.1, we're treating with the revocation of registration. And again, we're allowing for express methodology in respect of a conviction by a court for things under the Proceeds of Crime Act. Obviously, that includes money laundering, etc. We treat with the offenses under the Anti-Terrorism Act, the Economic Sanctions Act, and proliferation financing, regulations and orders, subsidiary legislation being enveloped into that. Section 87 of this law is where we treat with the methodology for record keeping. And we propose that every market actor shall have a positive obligation to keep records as are required under Proceeds of Crime Act. Now we amplify Economic Sanctions Act, Anti-Terrorism Act, etc. Section 89 of this law treats with compliance reviews. We are saying in the performance of its functions that the Commission can effectively manage and look at compliance reviews to determine whether there are breaches of the SEC legislation, the Proceeds of Crime legislation. Here at this point is where we add in the amplification for Economic Sanctions Act, Anti-Terrorism Act, etc. Compliance directions flow from Section 90 of the SEC legislation. And again, it was necessary to put in the concept of proliferation financing in subclause C. The last one in clause 3 in the securities legislation, which is being amended, is Section 146, where we say the Commission may issue guidelines. And this is critical because one of the failings of Recommendation 7.3 of the FATF recommendations, of those 40 recommendations, is the need to introduce guidelines under compliance directions for the market actors. Madam Speaker, I turn next to Clause 4, which is the final clause of this bill. Clause 4 proposes amendments to the Insurance Act. And in causing amendments to the Insurance Act, we are amending the latest version of the Insurance Act. That is Act number 4 of 2018. Madam Speaker, you will know that it took almost 8 years for that law to come into being. It went through 2 parliaments, the 10th and 11th Parliament. It was fortunately the Honourable Minister of Finance, Colin Imbert, that managed to give life to this legislation in its final form and the amendments to the Insurance Act, Act number 4 of 2018, and to cause its proclamation in parts. And Madam Speaker, we're proposing amendments to Section 4, 34(1)(c), 65(2)(a), 121(1)(e), 136(3), 147(8), and 278(1)(c). Again, Section 4 treats with the introduction of a definition for proliferation financing. That's the definition section of the Insurance Act. Section 34 deals with the revocation of registration. And now we're putting again a positive obligation upon the insurance businesses to see the implementation and observation of laws for Proceeds of Crime Act. We now amplify it to the anti-terrorism and economic sanctions, both primary and secondary law regime. Madam Speaker, when we treat with the amendment to Section 65 of the Insurance Act, we're asking for amendments under the rubric of corporate governance. It is in Section 65 that persons may be disbarred from management. And Section 65(2)(a), which we seek to amend, is where we say a person who has been convicted, previously we had Proceeds of Crime and Anti-Terrorism Act and regulations. We must now add economic sanctions and orders to deal with the concept of proliferation financing. Madam Speaker, we then deal with Section 121(1)(a), O as in Oscar. In 121(1), we're dealing with revocation of registration. This is where an insurance company or a person registered under this part may have the central bank revoke the registration. And Madam Speaker, we want to put a positive obligation where a person has failed to comply with an obligation under more than just Proceeds of Crime and Anti-Terrorism legislation, but also the Economic Sanctions Act. Madam Speaker, I turn next to the provisions which propose amendments to Section 136(3) of this legislation, the Insurance Act. It is in 136 that we treat with financial statements of intermediaries. And in dealing with the intermediary aspects, subsection 3 is where the auditor of every agency and brokerage shall monitor and evaluate compliance with Proceeds of Crime and Anti-Terrorism Act and the subsidiary legislation. We are now putting a specific obligation to treat with the Economic Sanctions Act and the orders issued. In this case, there are only 2 orders currently in effect, that against DPKR and that against Iran. Madam Speaker, the next section to be amended is Section 147(1). Section 147(1) treats with the auditor of financial institutions in the parameters of an audit of returns. It is in 147 subclause 8 that we ask for amendment, where the auditor of an insurer or financial company shall monitor and evaluate, again, compliance beyond POCA and beyond the Anti-Terrorism Act. We're adding in the economic sanctions regime and the subsidiary laws. Madam Speaker, the next section is Section 278(1), where the central bank may issue guidelines. And 278(1) subparagraph C is important, where we allow for the central bank to issue guidelines to aid in compliance with the Proceeds of Crime Act, Anti-Terrorism Act. Now, here's where we said, or any other written law. We actually had a debate with the assessors that that formula allowed for, obviously, the implementation of the Economic Sanctions Act, because it's any other written law. We asked, but they insisted that we not necessarily treat with this. We had no problems in adding in a more expanded version, because we are now, on this occasion, adding in the express reference to the Economic Sanctions Act and the orders, Madam Speaker. Madam Speaker, I'd remind that the Economic Sanctions Act has life in it. That Economic Sanctions Act, Chapter 8105, is a very useful piece of law. It is an Act of Parliament number 15 of 1994. It's been around for quite some time. It lay without operationalization for the entire time the UNC was in office and other governments. Where it became in need of operationalization was when we were presenting ourselves in a huff and a puff as ready in January 2015. My learned friends opposite couldn't be bothered to put that into effect. I don't think it is the fault of the member sitting opposite me currently right now. That was the job of their Attorney General to point that out to them. That was not done. I think that Naprima says the best Attorney General. I will just add, I wouldn't like to be in his shoes, certainly facing the best of the best, because, Madam Speaker, there are very unique circumstances facing certain people opposite, Madam Speaker. Which one? There's two charges here against, So, Madam Speaker, I don't know which one Naprima is referring to as winnable, but I wouldn't want to be the subject of a criminal charge. That's all I'll have to say. Madam Speaker, when we're dealing with the Economic Sanctions Act regime, we have brought this law into effect. We have operationalized the law. It is an important piece of legislation on our matrix. We require the improvements to satisfy the conditions of Recommendation 7.3 and Immediate Outcome 11. This law monitoring and implementation requires dedicated effort and purpose. It is perhaps why this particular 11th Republican Parliament has been very busy in agitating the need to meet our compliance markers under this regime of FATF and CFATF compliance. Madam Speaker, I look forward to the contributions of most of the members opposite in coming to this debate, and I beg to move.
Honourable members, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Financial Institutions Act, Chapter 7909, the Securities Act, Chapter 8302, and the Insurance Act, Number 4 of 2018, be now read a second time. Member for Naparima.
Thank you, Madam Speaker. Madam Speaker, we are here to discuss an act to amend the Financial Institutions Act, Chapter 7909, as you just said, Securities Act, Chapter 8302, and the Insurance Act, Number 4 of 2018. Madam Speaker, before I begin, I would wish to place on record of Hansard that we consider it an insult of the highest order to give us a bill on Friday evening to discuss today on Monday. No working days, no access to our staff, our research staff, in order to get in a fulsome way to debate this bit of legislation. And I ask myself the question, why it is this government brings hurried, ill-conceived legislation subject to little minimum analysis that doesn't give us time to have adequate reflection on the bill and then speak about hurried passage of the legislation. Madam Speaker, we on this side are fed up of the disrespect that has been accorded to us on this side. And the time has come for those on that side to recognize that democracy requires a fulsome engagement that cannot be a subject to lack of transparency. And today we'll be discussing a lot of bills that deal with the question of hurriedness, rush legislation, and an attempt to reduce the information to which citizens have access. Madam Speaker, I could not help but notice that my friend from San Fernando West was edgy today, nervous today. And Madam, may I submit that it is because we have a powerful, large meeting, massive meeting in San Fernando, such that San Fernando West will not have seen. And he has seen the light. He has seen the light. And that is why we have pensions and whatnot being put in place today so that he could further.
Speaker, apart from the spitting.
So, don't like so. Do so, don't like so. Madam Speaker, but in the fullness of time, we shall see where the nation shall speak, and San Fernando West will be once more in the adoring hands of the United National Congress. Madam Speaker, I am getting tired on this side of blaming the member for Siparia and the PP government for all the failings of this government. I heard it from the member from San Fernando West. Probably didn't get the memo from the representative from Tobago West, who said, we're in charge now, and we will deal with it. So, Madam Speaker, I said, deal with it. Don't blame the member for Siparia. She is blessed. She is blessed. Madam Speaker, before I get, but I want to say, because I went to the market and people accused me of wanting to fix my pension and all that. I want to tell Trinidad and Tobago, I do not want no increase in my pension.
Pensions, yeah. We deal with miscellaneous provisions. All right? Please. And no, if you wish, member, I'm sure you can get an opportunity to speak then. Okay?
Thank you. Thank you. Madam Speaker, we are here to discuss the incorporation of ideas and requirements to get off the various blacklists. We are basically constrained by Security Council Resolution 1540 of 2004, which says, inter alia, all states shall refrain from providing any form of support to non-state actors that attempt to develop, acquire, manufacture, possess, transport, transfer, or use nuclear, chemical, or biological weapons and their means of delivery. We are here also to discuss the various FATF requirements and CFATF requirements. In particular, Madam Speaker, that dealing with proliferation financing. And they have defined proliferation financing, and I'll just read it, it's in the bill and has been included, as the act of providing funds or financial services which are used in part or in whole for the manufacture, acquisition, possession, development, export, transshipment, brokering, transport, transfer, stockpiling, or use of nuclear, chemical, or biological weapons, and their means of delivery and related materials, including technologies, dual-use goods, etc. etc., Madam Speaker. The question arises, Madam Speaker, of why are we here today? Why are we here? And we know, well, it is to meet the requirements of the international agencies to get us off the various blacklists. But I must comment that we are here today because of the sloth and incompetence of the government of that side, and in particular the Attorney General. Madam Speaker, as far back as June 2016, who was in government then? Siparia. We were in government. The CFATF report to June 2016. Where are we? June 2016, June 2017, 1 year. June 2018, 2 years. June 2019, we're here today. 3 years. Madam Speaker, CFATF told this government, and I quote, that government, I'm told, that we needed as a priority action, a comprehensive policy on the implementation of measures for targeted financial sanctions related to terrorism and terrorist financing needs to be done.
When did they say that?
3 years ago.
2016.
And it hurts, Madam Speaker, to hear them come here today, blame Siparia. For heaven's sake, you will blame her when she comes into government in 2020. It also said the ATA, that's the Anti-Terrorism Act, needs to be amended to provide clearly for requirements of the recommendations pertaining to designated persons, listing and delisting requirements, freezing and other related measures in keeping with the obligation of the UN sanction regime. Madam Speaker, 3 years ago, they were told, and another subsection, a comprehensive policy on proliferation of financing of WMDs need to be developed, weapons of mass destruction. Madam Speaker, the only weapon of mass destruction I know Trinidad and Tobago has. Member for San Fernando West of the PLM. Madam Speaker, when you read this, you cry. Because you look at the slothfulness of this government. Madam Speaker, the same document asked that government to put in place a number of measures. And Madam Speaker, when you read the measures, we are still found wanting. It is not by accident. It is not by accident, Madam Speaker, and the FATF public statement issued on November 3, 2017 identified Trinidad and Tobago as one of 9 countries as having anti-money laundering and financing of terrorism deficiencies. And here are the countries we will aim in with: Bosnia and Herzegovina. Oh, Speaker, oh Lord, Ethiopia, Iraq, Sri Lanka, Syria. Syria has no government. No government. We little better than them. We have a PNM government, which is slightly better than no government. Tunisia, Vanuatu, and Yemen. Those are the countries in which we are in company with. Madam Speaker, and I will talk later on about St. Vincent. And I'll speak of that with Marine Le Pen, and I'll get an opportunity to clarify something. Yes, I'll get an opportunity. Madam Speaker, the same document asks us, Trinidad and Tobago should ensure that financial institutions, primarily credit unions, take immediate steps to identify and verify the beneficial ownership of all accounts, including legal entities and arrangements that were in place prior to these amendments, right? And to take corrective action to rectify cases of non-compliance. So sometimes you ask the question, what do we need to do to get off the list? Because we come and we hear stories, and then when we legislate, we realize that we're still on the blacklist. Madam Speaker, credit unions, the same place where they ask us to deal with proliferation financing. They're credit unions. ECU, one of the largest credit unions in Trinidad and Tobago, has 8 branches in our country. Therefore, when you look at the figures from the Eastern Credit Union, where it has 180,000 members, it is worth $2 billion in assets and has paid out $47 million in dividends for 2018. One could see that this offers proper environment for money laundering and terrorist financing. But they come here today and they give us half-baked legislation, like the amnesty, that when you look at it, there are myriad and a plethora of inadequacies in that legislation. Madam Speaker, it is sad. It is sad. It is sad. Madam Speaker, there are reasons why we are here. We are here because when we left, we had our country in line and ready to take off with respect to being delisted. Madam Speaker, when we demitted office in 2015, and they like to go back to Siparia and when we demitted office in 2015, Trinidad and Tobago had an unenviable record, not only in the struggle for nuclear non-proliferation, but in disarmament diplomacy. Madam Speaker, according to the Institute of Disarmament Diplomacy, Trinidad and Tobago does not possess nuclear weapons, except I mentioned a colleague of mine. As a state party to the Nuclear Non-Proliferation Treaty, NPT...
4 and 6, Madam Speaker, is now connected a very serious position. And what does my friend mean about San Fernando West has weapons of mass destruction? You can't hear 48, 4 and 6. 4 and 6. That is an egregious insult.
Madam Speaker, maybe San Fernando cannot read, but the definition
Member for Naparima. whoever it is that has that device, please go outside, take off the device, and they could return. Okay, Naprima, allow you to continue.
Madam Speaker, the proliferation definition which they have included talks about the stockpiling of use of nuclear, chemical, and biological weapons. If the member for San Fernando West cannot read and cannot understand, then he should not interrupt me. Should not interrupt frivolous interventions. So I'm making the point that this that we are introducing today, we were ahead of our international requirements when we demitted office in 2015. He doesn't like to hear that. All he wants to hear is what Siparia has done and what Siparia has not done. What have you not done? And what you are still not doing? An embarrassment to Trinidad and Tobago. Yes, embarrassment to Trinidad and Tobago. So, Madam, the Institute of Disarmament Diplomacy states that Trinidad and Tobago does not produce nuclear weapons. As a state party to the Nuclear Non-Proliferation Treaty since 1986, it has signed and ratified the Comprehensive Test Ban Treaty. I'm just showing how we were up to date before 2015. Trinidad and Tobago is also a state party to the Biological and Toxin Weapons Convention, which is mentioned here, and is a state party to the Chemical Weapons Convention, the CWC. As of January 2012, and I was at the UN then, January 2012, Trinidad and Tobago is a state party to the Mine Ban Treaty and is a state party to the Cluster Munitions Treaty Convention. Trinidad and Tobago signed the Arms Trade Treaty in June 2013 and ratified it in September 2013 under the distinguished leadership of the then Prime Minister, Kamala Persad-Bissessar, who I am proud to say, under her hand, she signed it. We were up to date at the time, Madam Speaker. Not only that, Trinidad and Tobago signed the Latin American Caribbean Nuclear Weapon Free Zone Treaty. We were up to date. In October 2013, Trinidad was one of 125 countries to sign the joint statement on the humanitarian consequences of nuclear weapons from the UN First Committee. And then came the Right Honorable Faris Al-Rawi to government. We were ahead of the game, Madam Speaker. The FATF guidance on counter-proliferation financing, February 2018, speaks on page 5 about interagency cooperation and coordination, which includes material to assist countries in establishing a cooperation mechanism to counter the financing of proliferation as required under the various conventions, in particular FATF Recommendation 2. Now, this Attorney General believes in legislation and not understanding that the legislation has to be an interagency, comprehensive effort to deal with the question of proliferation financing. Let me show you how we were different on this same issue, Madam Speaker. Let me show you how we were better, how we were superior on this same issue. I will tell you, because the country has to hear. If we listen to fancy talk, but no action. The United Nations Office for Disarmament Affairs, UNODA, put out a release on April 15, 2015. Who was the Prime Minister then? Remember the Honorable Kamala Persad-Bissessar, former Prime Minister of Trinidad and Tobago. April 15, 2015. Remember we talking, this FATF is telling us we need an interagency cooperation. Here how we good. Here how we superior. As a quoting from their release. As part of its technical assistance to Trinidad and Tobago, to strengthen the national implementation of Resolution 1540 of 2004, which is the same UN resolution that is the basis for this proliferation, financial proliferation. UN LIREC cooperated with Interpol and the FBI experts to train law enforcement officials in the detection, handling of sensitive dual-use chemical materials and improvised explosives from the 3rd to the 5th of March 2015. So we were complying with the UN requirements. They brought experts from the FBI and United Nations to help us. Issues such as the importance of interagency cooperation for effective border control. Well, they cannot even protect our southwest borders, notwithstanding what they say. But we were linking up with the best and the brightest and best practices abroad to deal with these issues. Dialogue and outreach with the industry, because you cannot pass legislation here and you have chemicals that could be put together to produce weapons of mass destruction. All right, and dialogue and outreach with industry and control lists for dual-use chemicals. The same word I'm hearing here, look, dual-use goods for non-legitimate purposes in the definition. We were ahead of the game in the context of preventing the proliferation of weapons of mass destruction. So they were here, they came to Trinidad. We don't go abroad and fly and spend money on podiums and all sorts of. We tell them, come here. The experts come to Trinidad. So we had, well, they used to. Thank you very much, my friend. Right, so it dealt with related materials to non-state actors were highlighted during the 3-day workshop. And the participants were the police, defense force, customs and excise, the port authority, special forces. I didn't even know we had special forces. It's only when I read the release. And the fire department. That is a government that acts proactively and not one that continually has to respond to blacklists and threats. We don't know that. And blame everybody else except their own incompetence, Madam Speaker. We are meeting here, and I'll not get into detail, I'll just say, we're meeting here because really, this legislation has been brought hurriedly, like a thief in the night, with other legislation which I wouldn't comment on, because this is a cover-up to those legislation, in my view. I could be wrong, and I move on from there. Does this, I am concerned whether this AG, Attorney General, this Honorable Attorney General, understands UNSCR and other requirements to get us off the various blacklists. Now ask the question, how could a little island like St. Vincent, how Dominica and Bermuda get off the list? And a big country like Trinidad, we still huffing and puffing and bringing hurried legislation, even though we had 3 years warning from FATF. Hurried legislation, Friday for Monday, so that we wouldn't take time to fully ventilate this. Madam Speaker, my father always used to tell me as a school supervisor, watch anybody that comes with asking you to make hurried decisions. Always take the time to reflect, to have a dispassionate view on whatever is presented to you. I do not make hurried decisions. He was a wise man. My father, bless his soul, Rodney Charles. Yeah, good man. Yeah, bless his soul. Yeah, I do not make hurried decisions except in this parliament. Hurried. I know we can't talk about subcommittees and joint select committees, and I wouldn't go there. But one of these days when I publish my book on my sojourn in this parliament, when I publish the sojourn, it will make good reading for future citizens of Trinidad. And persons on that side will not look good in that day. Madam Speaker, I have dedicated my life to, I have to give this to Trinidad, the arm's length relationship with the executive, etc. Madam Speaker, CFATF speaks about 2 main approaches to its mutual evaluation report. CFATF, thing we keep hearing, Global Forum, we get mixed up because it's hurry nice talk, and we can't disaggregate what is the EU requirements, what is the OECD requirements, where's the Global Forum requirements, where's FATF requirement and CFATF. We have they give you no time in order to sit down and have a dispassionate reflection on it, Madam Speaker. But CFATF speaks about 2 main approaches in its mutual evaluation report, and that must be important to us. A global approach, as indicated in the UN Security Council Resolution 1540 of 2004, and its successor resolution. So they have a global approach, right, Madam Speaker? And then they also have a country-specific approach under UNSCR 1718 of 206 and UNSCR 2231 of 2015, and their future resolutions. Madam Speaker, I'm coming now to an important piece of information that I want Trinidad and Tobago to pay attention to. Earlier this year, I had reason to visit the United Nations headquarters in New York, where I was advised, Madam Speaker, that this Parliament was misadvised in the sense that in the preamble to... Misled. Misadvised? That this Parliament was misadvised. Yeah, in respect of the preamble to Legal Notice 185, that the UN Security Council resolutions 1696, and you could go and read it, 1696, 1737, 1747, 1803, 1835, and 1929 were no longer in force and were therefore incorrectly used as a basis for the legislation. I was told that by the senior officials at the United Nations who are responsible for it. They are not in force. It is only 2231. You have it? You have it? It is incorrectly. Madam Speaker, you see why I do not... The problem in this Parliament, the Attorney General speaks after me. So he says whatever he says, and I have no rebuttal. Right? That is really what it is. Now I will rebut. Now I will rebut. Huh? Now I will rebut. Madam Speaker, Hansard will show that on 3 occasions I acknowledged that Resolution Security Council Resolution 2231 existed and was valid and relevant to the debate. 431. Yeah. I acknowledge that Security Council Resolution 2231 existed and was valid and relevant to debate. The 3 instances are recorded in Hansard, January the 11th, 2019, on page 208. That is one instance. In Hansard of the same date on page 211, I acknowledge that Security Council Resolution 2231 existed. Yeah? Also on page 216, I again, for the 3rd time, told this House, Madam Speaker, 4321. I told the 3rd time, I told him that Resolution 2231 exists. Now, Madam Speaker, ignoring, and he did it today. The Honorable Member did it today. Ignoring these 3 acknowledgements that are on the public record, he got up minutes after to base his entire 20-minute old talk. I don't want to use the word diatribe. Fancy talk. So I had to pay the insults, right? For 20 minutes against me that I had not acknowledged the relevance of UN Security Council Resolution 2231 to the debate. I will take his words. I am grateful, Madam Speaker, for the opportunity to correct this manifest untruth. As recorded in the Hansard, January 11, 2019, on page 227. I give facts. He did it. Hear what? And I quote the member for San Fernando West. Naparima said, don't exist. That's Resolution 223, even though I had acknowledged it 3 times. Naparima said, don't exist. The UN website generates it, and today the same list, 2231 of 2015, pops up, and Naparima can't pick up a phone. You know we provided internet in this chamber. We provided for the ability to access the research. Madam Speaker, you see why I do not trust this Attorney General. And I defy him to do the research and prove me wrong. Because I am right. 2 faults on that side. Blame Separia and costs Naparima. All right, say negative and pejorative too.
No, I think what will happen and what might lead you down that road is, okay, I understand the passion, but just remember we're not in a carnival ban, okay? And therefore we will, and for all members, we'll conduct ourselves in a parliamentary way and use parliamentary language. Continue.
Thank you. Thank you. Madam Speaker, there's a lot of pent-up frustration. Madam Speaker, Yeah, I'll drink a little water and I will take a seat and ask San Fernando West to apologize if my information is correct.
Madam Speaker, I apologize that the honourable member can't read properly because I was not speaking to 2231 alone, and I will pull the Hansard and demonstrate the gross mistruth that my learned friend has said. But let him continue. Let him continue.
That's not prima.
Madam Speaker, you see why I do not trust the gentleman. He can't even apologize. The Lord has said that apology and recognition of your sinful ways are important to salvation. And while we are at it, Madam Speaker, I will ask him to talk to the elderly people in San Fernando, and they will tell him about a Mr. Spinks of Miss St. Madeleine Sugar Factory and what he did, Madam Speaker. But you see, that will be in my book, chapter 7.
We committed the lunch.
So, you see, I will invite him to the lunch. I know he wouldn't attend, Madam Speaker. One of my faults in life, Madam Speaker, one of my faults in life is one of my few faults, correct, very, very, very few faults, is that, I do not crave after money, Madam Speaker. I'm a man of simple means and simple desires, Madam Speaker. This suit was bought off the rack. It's not a designer suit. I do not zest, Madam. I do not zest with Saveros. I have very kerchief. I do not have kerchief in pocket and all this thing. I am a simple man, a man of the Lord, Madam Speaker. I wish I had $23 million. I wish. I would donate to charity. But we are here, Madam Speaker. All we have done today could have been done, where this report, 2016, it could have been done in February 2017. Because all we are doing is inserting proliferation definitions in critical parts of the bill. Right? The financial institutions bill, right? That's all we do. He come at gallery like it's so much work. The attorney, I could pay a 2x4 lawyer and give him 3 weeks, and he will do exactly what was done here. Madam Speaker, the Financial Institution Act.
Honourable Member for Naparima, the original. Members on the front bench. Members on the front bench to my right. Your original 30 minutes are now spent. You have 15 more minutes to complete your presentation.
Won't take most of that. Won't take much. So I had to read in 2 days with no staff. I had to read the Financial Institutions Act, Chapter 7909, which I learned was replaced by Act number 26 of 2008 and amended by Act number 17 of 2012, again in our time. And this Financial Institutions Act is an act to provide for the regulation of banks and other financial institutions which engage in the business of banking and the business of financial nature for matters incidental and related thereto, and for the repeal of the Financial Institutions Act 1993. Madam Speaker, and all we did was in the interpretative paragraph, we insert the thing. And you know, when you listen to San Fernando West, you believe it's great things. You add a paragraph in the guidelines to indicate that as part of the guidelines, they'll be guided by the Economic Sanctions Act or orders made thereto as they relate to proliferation financing. That is clause 10C. And then clause 33(2)A, persons debarred from management are people who are involved or convicted in proliferation financing. Additionally, Madam Speaker, if there are any other statutory provisions related to proliferation financing that are not complied with, a person can also be prohibited from acting as a director or officer concerned with the management of a licensed institution or financial holding company. Madam Speaker, that's 1 day work. That is 1 day work. I am not a lawyer, so maybe there are some intricacies that are required to make it 3 years work. But for me, for the life of me, I cannot see any serious, hard-working, first-world qualified person taking 3 years to do that. Madam Speaker, we also hear the Securities Act. And I had to learn. I start from scratch. What are the Securities Act? Well, I knew about the Securities and Exchange Commission. I knew about the Securities and Exchange Commission. But I had to read about the Securities Act and the changes that were made. And the changes that were made in this. And again, it is what I call cleaning up to include provisions, cut and paste, provisions of finance, proliferation financing to incorporate that in the legislation. So wherever you have like functions of the commission, you add that. Where you have revocation of registration, you take away the license, you include that you can take away the license for proliferation financing. No big thing. Record keeping, they're supposed to keep record with respect to that. Right? But when you come here in Parliament and I listen, I thought it was some great, a thesis that would take years to do compliance reviews, compliance directions and guidelines. That's what we're here for. And you give me 2 days to do this. So your incompetence on slot for 3 years, I have to pay for that in a weekend. Madam Speaker, when you get to my age, you love the family and your grandchildren. You love your grandchildren to spend time. So when my grandchildren came and said, Granddad, so-and-so, I said, get out. I have to see about the Attorney General's business. Yeah. Sad. Really sad, Madam Speaker. Madam Speaker, and you know the certainty on that side? They're just like my grandchild tells me, and just forgive me 1 minute. My grandchild tells me, Granddad, you mustn't eat pork. You wouldn't live long. I am 70 years old. My grandchild is 7 years old. And I'm getting a lecture on longevity. It reminds me of this house. I get lectures here on things that I know and they're not qualified to present on. And I have to sit and take this. It is getting harder and harder. We'll need to have a discussion, Madam Leader. We need to have a discussion because I do not know how long.
But you're quite good.
How long the Lord will give me strength to deal with the insults that Madam Speaker, the other, and they made it, he talked about it, and I have to talk about it. Marine Le Pen. I have to for 2 minutes. Yes. 2 minutes, Madam Speaker. Yes, it's relevant. Right, because you see, St. Vincent just got as a non-permanent member on the Security Council. And they said they believe in a number of things, and one of the things they believe is the non-proliferation of weapons of mass destruction, and they believe in complying with international regulation. Madam Speaker, at the United Nations, you speak to everyone. You do not speak only to friends. Ms. Marine Le Pen, a member of the European Parliament, came and invited some of us, and we wanted to engage her to find out what is her thinking on Islamophobia and nationalism and right-wing. So sitting on the side of me was the ambassador from St. Vincent and the Grenadines, Madam Speaker. Camilo Gonzalez, who was promoted subsequently from ambassador to foreign minister, and now he's finance minister in this. Madam Speaker, my friends call me from the United Nations and say, what is going on with this government? They're criticizing Marine Le Pen, whether we like her or not, and I don't. Right now, with the right-wing movement in Europe, she could end up president of France. In fact, the BBC published information that she's more popular than Macron. If she becomes prime minister, the day she lands, she's going to get on her desk the government of Trinidad and Tobago, in particular the member for San Fernando West, call her racist, call her all sorts of things, and we shouldn't, it is embarrassing to sit and eat with her. Madam Speaker, a prime minister and a member of parliament, you could say that in a rum shop, you could say that elsewhere, not in a parliament. Not in a parliament. You have to leave your options open. She may not be so.
Haven't got Marie Le Pen off your chest. You promise me you will make it relevant. Right. Good.
Madam Speaker, I'm grateful for your kindness today. Yeah, very, very much grateful. So, Madam Speaker, I won't be long. It won't be long. I just think that this needs proper ventilation. I do not want to say it should go to a joint select committee. I know they get tizzic when they hear that. Because they do not like people to analyze them, Madam Speaker. Scrutinize them. Scrutinize them. A former prime minister told us, when you oppose them, they get angry. But I'm not going there. I'm not going there. All I'm saying, you are the government of Trinidad and Tobago. In fact, you are my government. You are my Attorney General until 2020. Until 2020. And I want you to succeed. I want you to succeed. And I will ask you, cut out the arrogance.
You promised me.
Closing up. This,
but even in closing up,
come back
even
to
in closing up, I want it to be relevant. Or else, okay, or else, I'll have to invoke the standing order. So you promised me it'll be relevant. So bring it, tie it together now in closing.
Madam Speaker, with those few words, I take my seat. Thank you very much.
Member for Portis Bay North, St. Anne's West.
Thank you very much, Madam Speaker. Madam Speaker, now that Comedy Central hour is over, I'd like to return to the bill that is actually before us. And for the public that may have been following and switched off their televisions and are now switching them back on, just to tell them what this bill is actually about. A lot of noise and a lot of fuss was made, Madam Speaker. But what this is very, very simple. What it is fulfilling our international risking finance obligations for FATF to just add proliferation financing and the effects and economic sanctions to certain pieces of domestic legislation. But Madam Speaker, it could not pass the irony and the hypocrisy in listening to what was being submitted by the other side. And, oh, it took 3 years to bring this simple legislation, etc. I just want to remind the people of Trinidad and Tobago of a couple of things. We were never part of Global Forum. We were never part of the body of Global Forum. It was the UNC that signed us up to Global Forum, which then came with legal obligations that they did absolutely nothing about. And as the Minister of Finance was reminded me, Madam Speaker, when we came in, the deadline for the obligations under Global Forum were in September 2015. Imagine that. Absolutely nothing done to fulfill it. That is why we are on the blacklist. I'm responding to why we're on the blacklist. We are on the blacklist due to your irresponsibility of A, signing us up to Global Forum, and B, doing absolutely nothing to fulfill our legal obligations under Global Forum. Let's come to FATF now. When we came in as an administration and to form the government, we were immediately informed by FATF that nothing had been done, no fulfillment whatsoever, and we were about to be blacklisted. So once again, it is difficult to sit here, Madam Speaker, and to listen to the rants and the raves as to nothing has been done. Why has it taken us 3 years to reach this point of this particular bill? Madam Speaker, the truth is, lest the population be misled once again, that a tremendous amount of work has been done from September 2015 to now to get us to the point with both FATF and then on the second part, Global Forum, and get us up to our legal obligations. What this bill is here today, Madam Speaker, despite all the hype and all the exuberance of Naparima, as he made his very spirited contribution, is just to add proliferation financing to specific domestic legislation. So this simple bill, which is just 4 clauses long, at clause 2, the bill would amend sections 210 and 33 of the Financial Institutions Act, chapter 7909. I am happy that my friend spent his weekend reading the Financial Institutions Act. It's a very important piece of legislation that all of us as legislators should read. So that is a good way to spend this weekend. Also, it then at clause 3 of the bill is amending sections 4, 6, 57, 58, 87, 89, 90, and 146 of the Securities Act. Again, another important piece of legislation, Madam Speaker. And then Clause 4 of the bill is seeking to amend Sections 34, 65, 121, 136, 147, and 278 of the Insurance Act, number 4 of 2018. Madam Speaker, all of those amendments are simple amendments. What we're dealing with here, Madam Speaker, is proliferation financing, which FATF provides guidance on. And if I may be permitted, Madam Speaker, it's actually the definition which is now being inserted in those three pieces of legislation is as follows. Proliferation financing means...
51B.
Thank you so much for the invitation. Member, please continue.
Thank you very much, Madam Speaker. Madam Speaker, this is a response to what was being put forward before and to bring things back in context so that the public would not be misled. Proliferation financing means the act of providing funds or financial services which are used in whole or in part for the manufacture, acquisition, possession, development, export, transshipment, brokering, transport, transfer, stockpiling, or use of nuclear, chemical, or biological weapons and their means of delivery and related materials. So, Madam Speaker, what we're looking at doing here is deal with the introduction of economic sanctions into our domestic legislation to deal with this crime, a crime that is related to terrorism. Madam Speaker, any sensible person will know when you have a long list of obligations that need to be fulfilled, what you do is prioritize it. When we came in September 2015, our risking factors were under crisis. Correct. That is a fact. We came in and immediately we're being faced by persons saying that we're grey listed. There's the potential of us being blacklisted. So all of the fun and games, all of the screaming and shouting, all of the laughter, all of the attempts to make this a non-serious issue, I want to remind the population that if these things are not done, and the amount of legislation, when you look at the legislation that's been brought to the House, brought to the Senate, and passed by the Attorney General since September 2015, quite a lot of it is in fulfillment of our international obligations to prevent de-risking. That may not bother those on the other side because they did nothing to prevent it. In fact, they created the crisis that we face. Madam Speaker, what I'd like to say to the population, if we are de-risked as a country, what it means is we cannot have the luxuries of international banking. Wire transfers become a problem. International banks would now be told you cannot do business and transact business coming from Trinidad and Tobago. The implications of that we cannot even begin to imagine because of the global type of business that takes place in Trinidad and Tobago, not least of which in our energy sector. So, Madam Speaker, this is not a joke. This is not something that should be taken lightly. And I remind the population respectfully, this is just another step in us fulfilling our requirements. So yes, it is urgent. Yes, it is now a priority. But no, it did not take 3 years to bring this specific piece of legislation. It all has to follow a sequential process, Madam Speaker. So a few months ago, we were here debating, and it was a member for Naparima, if my memory serves me correctly, and I think he referred to it in his contribution, that debated the sanctions or the ability to impose sanctions on North Korea and Iran. And that leads me to another point, Madam Speaker. I had to write it down. The irony and the hypocrisy to hear that we as parliamentarians should be careful as to what we say in this House. And talking about if Marie Le Pen becomes a global leader, it will be on record from this side. And the President of France, as he so hopes, it will be on this side that she's a racist. Well, we stand by that statement. But it is a factual statement. Unlike what we faced, Madam Speaker, unlike what we faced... what we face by the irresponsible contributions by, for example, a member of Oropuch East, when he himself stood in this parliament and said, there are 400 foreign terrorist fighters from Trinidad and Tobago. As a former senior minister of government and a senior parliamentarian, said that in the loosest possible way. It then took us on this side, Madam Speaker, years of working with the international intelligence agencies and organizations to tell them that there is no basis in fact for what has been stated by the opposition in Parliament on the Hansard that there are 400 foreign terrorist fighters. The real numbers we've said repeatedly is about 130. The vast majority, women and children who accompany the husbands. But what you face, and he's right, but not in this instance, he's right that the effects that the loose talk by parliamentarians here can have on our international reputation. But those on the other side, Madam Speaker, with the greatest of respect, sometimes say these things intentionally and very loosely, knowing the damage that it will have on the country's reputation. We faced it as well as they stood here loosely for months talking about Venezuela and what are you doing with respect to the Venezuelans. And when the policy was rolled out, oh, you come with the ad hoc policy, etc. And they're talking, this is responding, Madam Speaker.
Member for Kumutu-Mansinala.
48-1, Madam Speaker.
Okay, so member for Portisby, North St. Anne's West, I get the drift, but I think you could bring it home and get to the substantive matter before us.
Very much, Madam Speaker. It was simply responding to the irony and the hypocrisy to hear that we should be careful as to what we say on this side. A lot of weather was made, Madam Speaker, about the fact that our sister country, St. Vincent, is now on the UN Security Council, and how, because of the things that we have done in Trinidad and Tobago, we are unable to sail at those heights and those levels. Again, complete misinformation. Apart from the permanent bodies, the permanent countries that are on the UN Security Council, the rest of the membership is done on a rotational basis. Trinidad and Tobago, very proudly, was the first Caribbean island in 1985 to 1986 under a PNM administration to serve on the UN Security Council. And what it does, there are hundreds of countries in the world. So what it does is there's now a rotation. And I am certain under our next PNM administration, we will serve on the UN Security Council once again. I'm also certain that under the United National Congress, all of the bridges were burnt with the international intelligence agencies. When we came in as an administration, we were told pointedly they refused to share information with Trinidad and Tobago between 2010 and 2015 because they could not trust who was in the room. Put that on the record.
Which government said so? Try and send it.
Another quote that I heard. We tell experts to come here. We don't spend per diem. Again, Madam Speaker. Madam Speaker, the irony and the hypocrisy of that statement. Of course they came here. FATF and CFATF come to do their site visits and their investigations and their inquisitions in the country, their training in the country. That is nothing to boast about. I am looking forward to the day, Madam Speaker, when the debate comes to the trips that were made to Brazil and the trips that were made to India under the former administration, with the long string bandwagons and the chartering of planes and who they took and who they paid for and they didn't pay for. We'll talk about per diems at that time.
Speaker, 48-1, please, because this has no relevance.
Member for Portisby North St. Anne's West, please continue.
Thank you very much. And the $18 million spent on the trip to India, not a single benefit to Trinidad and Tobago from a financial point of view. Not a single benefit. $18 million down the train. This one carrying handbag. This one
has nothing to do with his bills. There's nothing to do with his bills.
Carry my scarf, carry my handbag, make up my hair, do my makeup. I'm not waking up in the morning.
Madam Speaker, 48-1, 48-1.
I overrule 48-1. This is in response to something that was said.
What was said?
I just want to, Member for Superior, you are very experienced parliamentarian. And please, I don't want the reverb. All right? Same, Member for Naparima, I don't have to explain what was said. There's the Hansard. And I believe you were on your feet, so maybe you couldn't hear yourself, but I heard. Member for Port of Spain, North St. Anne's West.
Thank you very much, Madam Speaker. I can remind Madam Speaker what was said because I wrote it down in quotes. We tell the experts to come here. We don't spend per diem. They come here and they meet with us. Well, Madam Speaker, the reason they came here to meet with us is because that's the normal course of business. When you come to do a site visit, as that was done, the test date in January 2015, when FATF came to Trinidad and Tobago in January 2015, and they failed Trinidad and Tobago and told us that we are now at risk of being blacklisted because the government had done nothing to fulfill the obligations, Madam Speaker. Nothing to do with Madam Speaker. Madam Speaker, to say that persons come here to do training and that is what has been done, again, that is absolutely nothing that is unusual with that. I notice how nervous they become, Madam Speaker. When we begin to speak about per diems, we will speak more about beyond per diems, and we'll speak about the types of hotels that were used, the planes that were chartered. We will speak about the fact that Sri Lanka was told that the Prime Minister of Trinidad and Tobago would be coming for a state visit, but that Prime Minister then decided to go to Dubai to shop. And the embarrassment that this country faced. The embarrassment that this country faced.
Whip, you're getting a habit of shouting at me. No. All right? And I think we become a little too comfortable where we all sit and we shout at each other and we don't recognize the standing orders. I expect a greater standard from you as the whip. That's the position you hold. Member for Port of Spain North, St. Anne's West, could we get to the bill now, please?
Thank you very much, Madam Speaker. So, Madam Speaker, back to the bill. Madam Speaker, the bill also inserts in the financial institutions at Clause 2B after the words Anti-Terrorism Act. So that in itself, Madam Speaker, what it does is it shows us that the whole proliferation financing is dealing with terrorism. And as I was quoting the definition a short while ago, before I was distracted responding to the submissions from Naparima, Madam Speaker, and if I can come back to it now, proliferation financing really is the financing and the providing of funds and financial services with respect to nuclear, chemical, biological weapons, including both technologies, dual-use goods used for non-legitimate purposes in contravention of any written law or, where applicable, international obligations. So, Madam Speaker, what this bill, this very simple bill is doing, but the very importance of this piece of legislation is helping us to fulfill our international obligations to ensure that we're not de-risked. The tremendous work that has gone on, and when you marry this piece of legislation with other pieces that were passed, and I dare say others still to come, because it is an ongoing obligation. And when you read what FATF has told us, Madam Speaker, their recommendation number 7 of FATF standards requires countries, and I'm reading here from, Madam Speaker, FATF's guidance on counter-proliferation financing, the implementation of financial provisions of United Nations Security Council resolutions to counter the proliferation of weapons of mass destruction. Madam Speaker, just reading that heading of the document and understanding that right now as you read the document that there are two major global entities that the UN Security Council were focused on, and the member for Naparima and the Attorney General had debated some time ago, Iran and North Korea. When you read it, Madam Speaker, what it really is is to prevent the financing, the potential financing of weapons of mass destruction by whoever the UN Security Council has a concern about. So one can understand. The point, Madam Speaker, is when you're prioritizing legislation to be brought and fulfilling your FATF obligations and going through the various tick boxes of FATF and CFATF and holding all of the meetings, passing legislation, doing the training that was referred to, and carrying out all of our obligations, you have to prioritize what it is you deal with. So not too long ago, Madam Speaker, we were here dealing with non-profit organizations. We will deal with the credit unions. We dealt with the banks and their whole systems of reporting, etc. So it is not unusual, nor is it in any manner whatsoever a show of competence or incompetence to be debating this bill now. It's my respectful submission, Madam Speaker. It fits perfectly in to the timeline of the fulfillment of the obligations that the Attorney General has spent a lot of time in face-to-face meetings with these international bodies, telling them and understanding from them what it is required of us. And I'd like to take this opportunity to credit the Attorney General and his department and the workers who work along with him for going through all of these meetings and diligently and assiduously ensuring that we are not blacklisted, and in fact taking us off of the risk of being blacklisted by FATF and fulfilling our international obligations. Madam Speaker, this simple piece of legislation is designed to combat the potential of the use of these weapons in terrorist activity. And that is why it is dealt with, as you can understand, in the Financial Institutions Act, which that parent piece of legislation, Madam Speaker, governs financial institutions, our banks and the other institutions that carry out those types of work. The Securities Act as well. Madam Speaker, again, as a member for Naparima spent time over the weekend reading this particular act, and as he would have been able to attest as he focused on it, this is the act that is on our books to govern and to regulate all of the public liability companies in Trinidad and Tobago and all of the bond offerings, the public bond offerings and these types of things. Again, these are tools that can be used and assets that can be used in illegal activity, and in particular what we're looking at here is the proliferation financing. Madam Speaker, I'll go back now to the FATF guidance, where they say, Recommendation 7 of FATF standards requires countries to implement proliferation financing related targeted financial sanctions made under United Security Council resolutions. Recommendation 2 requires countries to put in place effective national cooperation and, where appropriate, coordination mechanisms to combat the financing of proliferation of weapons of mass destruction. Immediate Outcome 11 and certain elements of Immediate Outcome 1 relating to national cooperation and coordination aim to measure how effective countries are implementing these recommendations. Madam Speaker, put quite simply, what we're debating here today is in fact to fulfill what FATF has required in this paper. The United Nations Security Council has a two-tiered approach to counter proliferation financing through resolutions made under Chapter 7 of the UN Charter and thereby imposing mandatory obligations for UN member states. Madam Speaker, this is the important part. As FATF are saying, there's a two-tiered process. The first process is the global approach under the resolutions that my friends from Naparima and San Fernando West some time ago debated. That has to come first. And then the second tier is for us to pass exactly this type of specific legislation. So, Madam Speaker, it is quite wrong to suggest that this has come out of time or it is not taking place in a sequential order. In fact, it absolutely is. They go on to say that the proliferation financing related provisions contained in the UN Security Council resolutions of both approaches are complied and reproduced in their entirety. Importantly, Madam Speaker, FATF standards do not require countries to assess their proliferation financing risks, and this paper does not extend the FATF standards. What that simple sentence means, Madam Speaker, is exactly as the Attorney General was attempting to explain. It means that this was not high up on the list of immediate priorities, and it wasn't an immediate requirement for us to get out of the crisis situation that we found ourselves in. But now is the time, and now is an appropriate time, and that is why we're here today passing this simple bill, which is really for the insertion into 3 pieces of legislation of certain definitions and other language to ensure that we fulfill this obligation. They go on to say, Madam Speaker, nevertheless, an understanding of proliferation financing risks will likely positively contribute to a country's ability to prevent persons and entities involved in weapons of mass destruction proliferation from raising, moving, and using funds, and thus the implementation of targeted financial sanctions contribute to a stronger counter-proliferation financing regime. So what FATF is telling us is, look, you're not absolutely required at the outset to pass your domestic legislation. You need to be aware of it. However, understanding how proliferation financing works and then working it into your domestic legislation after the UN security resolutions are passed and the UN Security Council has taken certain actions, that is when you implement it domestically. And that is what is happening. So what triggered this, Madam Speaker, is the recent legislation that we debated, or the orders that were passed and proclaimed by the President to declare 2 sovereign countries in accordance with the UN Security Council resolutions. And now we're following up to ensure that our local domestic legislation prevents proliferation financing and puts it into the category it needs to be in, and also links it to our anti-terrorism legislation. And then they go on to talk about recent changes in the UN Security Councils on proliferation financing. Competent authorities, financial and non-financial stakeholders should note that the scope of funds, financial assets, economic resources subject to assets freeze has been expanded in recent resolutions for the sanction regimes relating to the DPRK and also to Iran. So, Madam Speaker, I'm spending this amount of time to just let the public know that despite the rants and the raves as to this has taken so long to happen, it could not happen before. The time is now, as FATF have said in this document, and as FATF have said in their guidance on counter-proliferation financing, which is dated February 2018. They said the resolutions had to be passed first. They said you had to prioritize what you do. They then gave guidance on the type of legislation that needed to be passed, which was passed not so long ago. And then you bring this type of simple bill just to insert in our domestic legislation at the appropriate points, the protections for proliferation financing for a definition, but also more importantly, the potential for economic sanctions, Madam Speaker. They then go on to talk and give guidance, Madam Speaker, about identifying and designating persons or entities who are financing or supporting weapons of mass destruction proliferation. So again, in the fulfillment of that suggestion and those obligations that FATF have asked us to fulfill, that is what this bill is about, Madam Speaker. So what we're doing is can purchase insurance policies as a methodology for financing weapons of mass destruction. This is all about terrorism. And quite frankly, Madam Speaker, what this is small Trinidad and Tobago's part that we're playing in a global fight against terrorism and our global fight against weapons of mass destruction. The little role that we can play, we're playing, and we're fulfilling our international obligations. Madam Speaker, I heard, and I assume it was really a bit facetious, the speaker from Naparima say, well, what do we need to get off of all of these lists and being on the grey list and being on the black list? That is a question that we've asked. We have asked at cabinet level. The Attorney General has set out very clearly for us that due to the deep hole that we were in, he set out the list of priorities, the checklist that we need to go through. And those are the efforts that we've been making over the last 3 years, Madam Speaker, as we go through the tick list. This is just another item on that tick list to ensure that we're not blacklisted. And I repeat, we are not blacklisted by FATF. In fact, if I understand correctly what the Attorney General has told us, we have been upgraded. There's the we expect to be upgraded. We've been working hard. He's been getting good results. They've been telling us the blacklisting, unfortunately, is with the EU and with Global Forum. Unfortunately, that is a whole other set of obligations, but in us fulfilling FATF, and we've had the conversations with the bodies, with FATF and with others, to ask for their support when meeting with the EU and Global Forum, to tell them that the standards and in the limited time that they're putting on small countries such as ourselves is not realistic, and we need more time to be able to fulfill those obligations. But I'm happy, Madam Speaker, to hear my friends on the other side are alert to the fact of the blacklisting, and I assume that when we come with that legislation to ensure that we're not blacklisted, we will have their support to ensure that it is passed. Another interesting comment from the Speaker from Naparima, Madam.
St. Anne's West, your original 30 minutes are now spent. You're entitled to 15 more minutes to complete your contribution. So that, if you wish, you may proceed.
Thank you very much, Madam Speaker. Madam Speaker, another quote. I don't know what is the obsession. Madam Speaker, with San Fernando. But I am happy and I am sure that my colleague from San Fernando West, who is very safe and secure in San Fernando West, is happy to hear that is where you're going. And I'm hearing that this is a forum.
They're looking for them.
Right? It's a forum.
They're looking for them.
So what I was going to say, Madam Speaker, before I got engaged in a little old talk with my colleagues on the other side, is a quote that was made, a quote that I took down from the Speaker for Naparima. Global Forum requirements. We get tied up with his normal exuberance and his normal wailing of the arms and his excited spirit. His excited spirit, spirited contribution. Madam Speaker, to remind my friends on the other side, to remind my friends on the other side, and in particular the Speaker from Naparima, the reason we get tied up in Global Forum was the former Minister of Finance, Minister Dukaran, is the one who went and committed us to, it was Hawaii? Minister, no, it was Dukaran.
Then Hawaii.
Former Ministers of Finance between 2010 and 2015 are the ones who committed us to Global Forum. And then unfortunately did us the disservice of not going through the checklist, not going through the tick list, not going through, Madam Speaker, what needed to be done to make sure that we didn't find ourselves in this very unfortunate circumstance. Madam Speaker, another important part of the legislation, the simple bill that we have before us today, is dealing with the freezing and prohibiting of dealing in funds or other assets of designated persons and entities. What this means, Madam Speaker, is it is giving the authorities the ability to impose economic sanctions on anyone that they have sufficient evidence is engaging in proliferation financing. So, Madam Speaker, put quite simply, the message that I ask comes from this House today to the international viewers and to those who are rating us and to those that are charged and tasked with the responsibility of rating us and deciding whether we are to be grey listed, we're to be blacklisted, or we to be upgraded, is Trinidad and Tobago in this Parliament is doing all that it can. We're working sometimes together to make sure that the necessary domestic legislation is passed. Because one thing I'm sure of, I am certain that all of the members of this House, including those on the other side, do not want to see Trinidad and Tobago end up in a permanent blacklisting, or to see Trinidad and Tobago be de-risked, or to see Trinidad and Tobago lose our correspondent banking. Because I'm sure many have international accounts or put simply, want to be able to send funds for their children at university, want to be able to send funds via wire transfer to their friends, to buy goods, to buy drugs for the hospital, to buy what is necessary for national security.
Honorable members, it's now 4:30. This House now stands suspended. We shall resume at 5 p.m.